last adjourned.
Thank you, Deputy Scott. Members of the jury, welcome back. Thank you as always for being on time. And we are ready to resume with the state's case in chief. So the state may call their next witness.
Yes, Your Honor, the state calls Investigator Gearkey with the Sandy Springs Police Department.
First and last name.
Ryan Garrick, RyanGeherrickE.
Now, good morning.
Morning.
Now, you were employed in 2018 in Sandy Springs. Where are you currently employed?
Currently employed in real estate.
Okay. How long, and what years did you work at Sandy Springs Police Department?
2016 through 2020, end of 2020.
All right. And can you describe your duties while you worked at Sandy Springs?
Yes, I was a Sandy Springs police officer, a member of the North Metro SWAT team, and a investigator for the detective with the city of Sandy Springs.
Okay. And at that time, were you post-certified?
Yes.
And at any point, did you come to assist in the investigation involving a homicide at 1095 Woodbine Road?
Yes.
And that was also in 2018?
Yes.
Can you tell the court, at what point did you become involved in that investigation?
June 26th of 2020, Detective Williams notified me that he received a Google return on a search warrant he applied for regarding a suspect and a cell phone number.
Okay. What did you do after you received that information from Detective Williams?
Detective Williams and the Sandy Springs Intelligence Unit started investigating the phone number, which came back to a suspect, James C. Jones.
Okay. And what did you do after that?
We conducted, after running Mr. Jones through NCIC and GCIC, he came back to an apartment complex in DeKalb County,
Okay.
Decatur.
And so once you receive information about an individual of interest, talk about the techniques in place to attempt to locate that individual.
Yes. Detective Williams requested an exigent ping from Verizon regarding a cell phone tower ping to see where the suspect was actively, where the suspect was at.
Okay. And at that time, do you recall whether you had an actual phone number that you were focusing in on?
We did. The phone number was 404-838-3782.
Okay. And were you able to develop any leads upon searching those databases?
Correct. When we found that, the suspect, so when we started getting the Verizon pings, it was located in DeKalb County in a radius, and we noticed that inside that radius was the suspect's address listed on his driver's license.
Okay. So at that time, your testimony is that you had information about his driver's license?
Correct.
And you had information about the suspect's phone number?
Correct.
Okay. And what did you do after that?
Detective Williams started having the pings emailed to my Sandy Springs email to monitor the location. The location did not change. So Detective Williams asked the Sandy Springs Street Crimes Unit and myself and Sergeant McGowan to go put surveillance on the apartment while he obtained a search warrant since the suspect was not moving and the returns were coming back in the same location of his apartment.
Okay. Now you mentioned ping. What are you referring to when you say ping?
That when a cell phone is being used, is that it's hitting off the closest tower, and that was the tower within a radius.
Okay. And when you say radius, what is the general radius in ballpark terms?
I don't recall, but it's a certain amount of miles.
Okay. And is this something that is believed to be happening in real time?
Correct.
Okay.
Correct. It was every 15 minutes we were getting updated cell phone.
And was this a team of investigators and officers?
Correct.
Okay. Um, so walk us through how you get to the point where Mr. Jones is apprehended.
So we get to the point where Mr. Jones is apprehended. We served Detective Williams received got a search warrant to search the apartment complex of the listed suspect's address. The search warrant was executed and Mr. Jones was not found, but that's where we met. Comes to find out Mr. Jones's uncle, James.
Okay.
Drawing a blank on the last name.
All right. And after taking that step, what did you do next?
We were unable to find the suspect, so Detective Williams asked me to call the phone number that we were actively tracking to see if we could meet up with.
Okay. And at this time, based off that radius, how close do you believe that you may or may not be from the suspect at this time?
We believe that the cell phone,
Object to speculation.
Mr. Fawcett?
Your Honor, we're talking about the officer's actions at the time the search is happening. And so this is something that is dictating the next actions that he's taking, in particular, how close he thinks the suspect is.
And I think we addressed this argument yesterday or the day before on another issue. And this is speculation.
All right, Mr. Fawcett, can you re-ask the question
Okay.
as you
I
meant to
will.
phrase it?
I will. At the time that you were, at that very moment when you were speaking to Mr. Jones's uncle, did you have an idea as to a range that Mr. Jones may or may not be from you at that time?
yes. So
Okay, and, just to that objection, that'll be overruled. You can answer the question if you remember it.
yes. So speaking with the uncle, he said that Mr. Jones used to live at the apartment, no longer does, but he visits them every 7 to 8 days, and it was around the time when the suspect would be visiting usually.
Okay. All right. Walk us through how you actually, what happens when you call that phone number?
So I called the phone number and I asked if this was James, and the suspect said yes. Good.
All right. And if you could go over the content of the jury?
Yes, I tried to have the suspect, see if I could meet with the suspect about investigating a burglary. The suspect then asked me if I would send him an email with the photo lineup of the suspects. I asked the suspect what was a good email address, and that's where he said jamesjones04@gmail.com.
Okay. All right. Did you make note of that email that the person of interest had given you at that time?
Yes.
All right. What did you do after you received that information from Mr. Jones?
I asked if the suspect was still willing to meet, and he hung up on the phone.
Okay. Did you at any point make contact with the person of Mr. Jones?
No.
Okay. At any point, can you tell the jury if Mr. Jones was apprehended during that
Yes.
investigation?
After serving the search warrant and having a phone call with the suspect, I told the lead detective Williams all of my information that I've gathered, and he sent the information to a fugitive task force for the United States Marshals.
Okay. And are you familiar with where Mr. Jones was apprehended?
Yes, he was apprehended in a U-Haul facility in DeKalb County.
Okay. And did you actually make your way to that U-Haul facility?
I did at first. Detective Wilson and Sergeant Romero went to the U-Haul and onto the U-Haul facility in the actual storage unit, and secured it. And I went to Dunwoody Police Department to obtain a search warrant for the U-Haul facility.
And is that something as typical police procedure to obtain a search warrant to look at different properties?
Yes.
Okay. And that's your testimony is that you did that in this case?
Yes.
And what did you do after you obtained that search warrant?
Once I obtained the search warrant from DeKalb County judge, I went to the U-Haul facility where the suspect was located and handed that search warrant to Sergeant Romero.
Okay. And any point during that investigation, did you actually search that U-Haul facility?
Correct. Sergeant Romero, Detective Wilson, Detective Saltel, and I searched the unit.
All right. And at this point, was it your understanding that this was a home invasion,
Correct.
the investigation?
Home invasion and homicide.
Okay. And did you find anything at the residence that was consistent with the burglary homicide investigation? Well, at the U-Haul facility, did you find anything?
Part of the scope of the search warrant was flex cuffs, latex gloves, any electronic devices, and any items involving the victim.
Okay. And were those items that were located at that U-Haul facility at the time James Jones was apprehended?
We did find gloves, work gloves, latex gloves, flex cuffs. We also found black tennis shoes with a white trim. That was part of the search warrant, and also a black duffel bag. That was also part of the search warrant.
Did you find or locate anything that could be used for restraint of any type?
Yes.
And what was that?
That would be the flex cuffs that I referenced earlier.
Flex cuff. Did you also find, or was that flex cuffs, is that the same thing as, say, zip ties?
Zip ties,
Okay.
yes, correct.
All right. Did you find, like, did you find a multiple zip tie flex cuffs, or was it a single, or do you recall that?
I don't recall.
Okay. Now, have you had an opportunity to look at photographs from that date and location when you searched the U-Haul facility?
Yes.
Okay. I'm gonna call the numbers out, Yana. This exhibit is a fairly large number of photographs, but I advised the court that I pulled several out yesterday. But I do have those documented, so I'll read those into the record when I. If you could take a look at these exhibits, and I'll start you with these, and tell the court if you recognize.
Yes.
Go ahead.
Let's get here, and these are just, and tell the court if you recognize these.
Yes.
All right. How do you recognize those exhibits that I have just shown you? And I'm going to read the numbers of those exhibits into the record. Just so I can make this clear, yesterday, Your Honor, the state tendered several photographs from the U-Haul facility yesterday. The total number series of the U-Haul photographs is 297 through 471. At this time, the state has tendered to witness exhibits 298 through 305, exhibit 307, exhibit 309 through 340, exhibit 347 through 350, exhibit 342 through 357, exhibit 359 through 447, exhibit 450 through 452, excuse me, exhibit 450, exhibit 452 through 453, exhibit 456 through 458, and exhibit 460 through 462. So clearly I've made this much more complicated by separating those photographs out yesterday, but I will present the court with a new exhibit list to clear this up. All right.
All right, any objection to the exhibits as described from the defense? All right, they are admitted.
All right. Now, as to those exhibits I've named, can you tell the court, are those the same images? Do you recognize those images from searching that U-Haul facility?
Yes.
Are those images images depicted a fair and accurate representation of what you observed on that date?
Yes.
All right. Your Honor, at this time, the state will move to tender all the named exhibits into evidence at this time.
All right, I think we already handled that.
Okay. All right.
You may proceed.
Okay. Okay, Mr. Garrick, this is exhibit 303. Can you tell us what we're looking at?
My screen it's asking me to mute or unmute, so I can't see it.
Just
Do
hit
you want me to
unmute.
look here?
Well, just hit mute on that screen. You can touch it.
Mute?
Yeah, you can just touch it.
All right.
All right.
Go ahead.
Can you tell us what we're looking at exhibit 303?
U-Haul for storage facility,
Okay. And exhibit 3010.
a hallway in the facility.
All right. And I'll show you a photograph of the interior.
We went through all of this yesterday. This is a little bit duplicative.
All right, Mr. Fawcett, if we can just, I'm sure you're leading up to it, but focus being any photos or evidence not previously covered.
Can you tell the jury how many officers were involved with you with the search of the U-Haul facility?
3, Sergeant Romero, Detective Wilson, and Detective Sawtelle.
Okay. Okay. All right. And were you able to obtain any documentation, any documents while you were at that U-Haul facility?
Yes.
I'm going to show you exhibit 382. Can you tell the jury what this exhibit is?
It is a Verizon bill that comes to the suspect, James Jones.
Okay. And was this a document that you retrieved while you were searching that U-Haul facility?
Yes.
And do you see anything on that state's exhibit that indicates who this Verizon bill belongs to?
James Jones.
And do you see a phone number on that state's exhibit listed corresponding to James Jones?
Yes.
What is that phone number?
404-838-3782.
And is there a period listed on this Verizon bill that this bill, I guess, correlates to?
Yes.
And what is that bill for, that period?
July of 2017 through November of 2018.
Okay. And was that in fact the number that you called when you were attempting to make contact with James Jones?
Yes.
One moment. That's all I have to.
Cross-examination.
So let's see, you participated in this investigation back in 2018,
No, ma'am. 2020.
2020.
Yes.
Had you had any involvement in the investigation in 2018?
No.
No? R.R. Gericke,
Yes.
that is you.
Yes, ma'am.
Sandy Springs Police Department.
Yes, ma'am.
Do you ever prepare a police report in this matter?
Yes, I wrote the supplemental of my involvement in 2020.
Do you have that with you?
Do I have the report with me?
Yes.
Yes.
Can I have a look at it, please? Now, you made a call to a telephone number.
Yes.
And did you record that telephone call?
I do not recall.
You don't recall whether you recorded a telephone call?
Correct. I do not recall if I recorded the phone call conversation or not.
Okay. It would have been fairly important, would it not?
Yes.
And had you ever spoken to this person, James Jones, prior to that date?
No.
Do you know what date you made that phone call?
June 22nd. I'm sorry, June 26th.
June 26th phone.
Yes,
Okay.
2020.
June 26, 2020, you made that phone call.
Yes.
Okay. And you spoke to a person,
Who stayed, I asked if this was James and they said yes.
and you did not know that person's voice.
No,
You do not know whether that person was in fact James Jones.
the phone number came back to a James Jones with a driver's
I-
license, and the phone number was attached in GCIC and NCIC to a James Jones. So
but
I
you
had,
do people sometimes answer other people's phones?
it's possible, yes.
And that phone call took place, you say, 5 years ago?
Correct.
And you remember every detail of that conversation?
Not, I'm sure not every detail, but what was in the report.
Okay. And you then participated in this search of the U-Haul.
Correct. After the suspect was apprehended.
I would like you specifically to look at photo 389.
Hold on 1 second.
Exhibit 389.
389? Yeah.
389 should be in front of you. You can look at 388 while you're about it. So I don't send you fishing again. I did send you fishing again. I apologize.
Sorry, they're just a little out of order. Okay.
Okay. What is exhibit 389 a photo of?
It looks like some type of liquid that says female hormone.
It is a medication, is
Medication.
it not?
Yeah, I would assume so. I'm not a doctor.
It appears to be a medication,
Yes.
and it appears to be a female hormone medication.
That's what it says here, yes.
And photo 388 or exhibit 388,
Yes, ma'am.
what does 388 show?
A messy room with what looks like a laptop, trash, and disposable syringes.
A box of disposable syringes.
Correct.
And perhaps Mr. Fawcett will assist me by publishing photo 389 for us. Whose hand is holding that?
I don't recall.
Okay. Right. Thank you. Thank you, Mr. Fawcett. Right. Now, let's go back to what you recall finding. Well, first of all, what were you looking for there?
For the search warrant through Detective Williams, we were looking for flex cuffs, zip ties, gloves, electronics, a two-way handheld radio, personal items belonging to the victim, and then any and all DNA evidence that could come back to the victim.
And let's see, you found flex cuffs.
Correct.
You found black tennis shoes.
Correct.
Do you own black tennis shoes, sir?
Yes.
Committed any murders recently?
No.
Do you do any work around your home?
Yes.
Your Honor, I'm failing to see the relevance of this line of questioning.
Overruled.
Do you have work gloves in your home?
I do, in the shed, yes.
Do you do any cleaning around your home?
Yes.
Do you have latex gloves in your home for cleaning?
Yes.
Again, committed any murders recently?
No.
Did you swab the shed?
Did I swab the shed?
Yeah.
No.
Or did anyone swab the shed for DNA relating to Miss Thomason?
No.
Now, there are more than one person in the world named James Jones, correct?
I don't know that answer.
You didn't do the research, did you?
Sandy Springs Intelligence Unit did.
And when you went to the apartment and met with the uncle, what was his name?
James Eric Walker.
And you searched his property, correct?
Mr. Walker's, yes.
And the phone was pinging off his property.
No, it was pinging off a cell phone tower in the radius of the apartment complex.
Okay. So how far is the storage unit from the apartment complex?
I do not recall.
No idea at all.
I know it was within the radius, but I do not know the exact mileage.
Now, I think you also told us a few minutes ago that you did not participate in any way in this investigation back in 2018.
Correct.
And you've got a good memory.
Yes.
Going to show you what I've marked for purposes of identification as defendants 33. Recognize that document, sir?
I do not recognize it, but I do remember this now, yes.
What is it? What is that document, sir?
The document is a supplemental where when I was on patrol, I helped search, it looks like an apartment, or hold on. I helped door knock for a stolen vehicle that was recovered.
Relating to this case?
Well, it says here that it's regarding a stolen vehicle recovered case, but obviously the supplemental here is to this case here. But I was not in CID at the time, I was on patrol.
So let's see again. With your sterling memory, you call a number, you don't know whether you recorded that phone call or not. Where did you make this phone call from?
The parking lot of the suspect's apartment where we served the search warrant with other police officers.
Anybody else present when you made that phone call?
Yes, the phone was on speaker, and Sergeant Levy was present.
And you called the number, and what do you say?
I asked if this was James, and the suspect said yes.
James, just James.
Yes.
And?
I asked if, when I spoke with James, I asked if he was willing to come meet with me to see about a investigation of a burglary and do a photo lineup for a burglary I was investigating.
Did you tell James anything about the burglary you were investigating?
I said that I was investigating a burglary, and he did say that he called about a burglary in progress, but would be of no help.
So he said he couldn't make an identification.
He said, correct. He said that he would not be of assistance.
Okay. That's slightly different, isn't it?
How so?
Well, let's see. He told you he could not make an identification, correct?
Correct.
What did he want you to email him?
So as I kept asking in various different ways if he would meet with me for a photo lineup for this investigation, or for the burglary that I was allegedly investigating for him, that's where he said that if he asked if I would email him a copy, email him the photos. And that's where I asked for his email address.
Emailed him the photos after he had told you he could not make an identification.
The suspect, Mr. Jones, was the one that offered up to give his email address to me.
He offered his email address.
Correct.
And he never, well, and sorry, let me leave it at that for a moment. I have nothing further.
Any redirect.
No, Your Honor.
This witness speaks.
And Your Honor, no, I'm not going to ask to admit 33.
All right. Any, can this witness be excused?
No objection.
All right, you can step down, sir.
All right, Dr. Sullivan is here.
All right. All right. Members of the jury, I need to take 5 to take up something outside of your presence. We should be back with you shortly. All right.
For the jury.
All right, Mr. Siminoff.
Judge, I'm sorry, before we get into it. Imagine how. Great.
I mean, I wasn't.
We'll run by. I need 1 minute.
All right, that's fine. We'll hold in place. You can, I think, return 33. All right.
I apologize, Ron.
All right, Mr. Siminoff. What new matters did you want to have be considered or placed on the record?
Yes, there are, 2 things that I want to bring up before Dr. Sullivan takes a stand. The first matter is I want to make a motion for the court to reconsider the objection under 702. The reason for that is I was able to access the recording of the proceedings from yesterday on YouTube. I have to thank the court for streaming on YouTube and recording those. That's very helpful. And in denying that objection, the court mentioned that my cross went to the weight of the evidence when we were diaring Dr. Sullivan. And when I was cross-examining Dr. Sullivan, I was asking about what the standard procedure for determining cause of death for medical examiners is. And then we kind of got into how unusual it is for accused just photos. So that doesn't go to weight of the evidence, that goes to 702(2). That second problem, it goes to the reliability of the methods, principles, or techniques. That is different than just weight of the evidence, which we can talk about on cross in front of the jury. That is different. There's a determination that needs to be made about how reliable and how common practice the method that is justifying the expert opinion is. That's not just weight. Yes, we can cross Dr. Sullivan on weight based on that as well, but there needs to be a prior determination of how reliable this method is. That is slightly different. And determining a cause of death in photos, she testified herself that the gold standard for determining cause of death for medical examiners is autopsy. There were no tests, and by the way, when the court was denying the objection, it kind of focused on my cross. And what we were able to get from Dr. Sullivan, this is not our witness. It's not our responsibility to establish her as an expert or to rebut her expert credentials. It's on the state to establish her expertise and her opinion as valid as an expert, and that it's based on reliable methods and principles. So that's not on us, that's on them. And to that point, we've heard no testimony on whether this method, this particular method of determining cause of death, so a little bit of photos, has been studied or peer reviewed. There was no testimony as to what the error rate might be to any conclusions in using that method. So there was essentially no testimony elicited from the state as to reliability of using a method like this to determine cause of death. Aside from Dr. Sullivan saying, yes, I can do it. So they have failed the 702(2) test for this method. They have not met their burden to establish that and hold her out as an expert to provide an expert opinion as to that. So I want to motion to reconsider that. The second thing that I want to bring up is the court did rule on the Smith versus Arizona objection that we had for the confrontation clause issue, but at the end of proceedings yesterday, I think the court mentioned it was overruled, but I'm not sure that it was overruled so much as it was granted in part. Because in the discussions before the court stated its final ruling, I think that the court had.
What are we referring to now? I'm not following.
Confrontation clause portion of it. I'm past the 702. I'm on to the second part of my.
And what were you saying I said was overruled?
You right at the end, you said that the hearsay and confrontation clause objections are overruled.
Okay.
I think. And but listening to the events leading up to that doesn't sound like the confrontation clause objection pursuant to Smith versus Arizona was overruled. It sounded like it was granted at least in part because the court wanted to set, I think, quote unquote guardrails as to what she can testify based off of. And it seemed like the court was going to let her testify as to conclusions made solely based on a review of the photos and not any conclusions based on Dr. Henniger's report, her review of the report, or any of his findings during the autopsy. That's what the recording sounded yesterday, basically limiting the testimony to that paragraph that I read into the record yesterday.
Are you just seeking clarification on that?
I am seeking clarification on that. And beyond that, I'm seeking for the court to, before the jury comes back out, to direct Dr. Sullivan on that. Because even during her voir dire, when we were talking to her, she kept wanting to refer back to the report for Dr. Henniger, kept saying, well, I peer reviewed it. I read the report. I based my findings off of it. Right from the get-go, she started talking about that. And if she starts talking about that in front of the jury and judge, I'm just playing with the court. I'm asking for a mistrial. So I think we need to clear that up and give fair warning to both the state and the witness about what's going to happen if we start getting into that. Because the photos, the court has ruled on that, basing an opinion off that as far as Crawford and confrontation clause, Smith versus Arizona. The court has made a ruling on that, but if we get past that, if there's any conclusions referenced by Dr. Sullivan that Dr. Henniger made, then there's a whole other problem. I think then we're off to races.
Okay,
So-
understood. Let me get any response from the state.
Yes, Your Honor. I think just as a preliminary, the reason why we didn't get into reliability and that stuff, because the court asked me not to, to qualify her and go through qualifications and go through techniques. So that's why I didn't do it. I think also, I would ask the court to reconsider its earlier motion on and find that Smith versus Arizona and I believe it's Weathers v. State in Georgia does not apply because those cases are using lab equipment to test for controlled substance. I believe both of them are. That is not the same situation. What a medical examiner is basing his or her opinion on is their visual examination of the evidence and drawing medical conclusions for that. So I do think that's a really different situation. I understand. I think if I come in here and try to get a DNA, result from someone who just looked at notes, I get that. But I think this is a unique situation. And I think the current case law in the state of Georgia is still, and that case has not been overruled. So I'm not gonna take up any more time with the court, but those were my reasons. Those are my reasons for the court to distinguish Smith versus Arizona from this case in here. And that basically this is, and I hate to say uses lack of scientific equipment other than maybe a scalpel or whatever. It's a different situation. I don't have a problem, whatever guardrails the court wants to put in with Dr. Sullivan. I have no problem following those. I think my intention is merely to have her explain to the jury the cause of death of Kate Thomas.
And so is there anything substantively you're saying now she should be testifying to or referring to based on you making this argument now?
Well, I think it's the same argument I made yesterday that she can base her opinions on review of the photographs and base her opinions on medical conclusions that she would make as a licensed medical doctor in the state of Georgia. Well, anywhere technically, but as a licensed medical professional, that she would make her conclusions based on the pictures that she saw. And I think she did explain that to the court. She said, I saw the pictures. That would be the cause of death is the injury to the back, the stab wound in the back of the head.
All right, well, let me start there just to clarify to the extent we need to, which is that what you're describing is what I thought was consistent and in conformity with Smith versus Arizona. And I think it was the Watkins case is the one time now Georgia has had a chance to look at that. Granted, it's in the context of drug testing, but the holding was that factual assertions made by someone else, relied on by an expert, admitted for the truth of the matter asserted, are what transform that new expert into a mouthpiece. And that's what we're trying to avoid. So what the state is telling me and what the testimony was yesterday is that she's coming to her own independent conclusions based on the photos. And so I think that's where we left it yesterday. I think that's where we are today as it relates to that. So to the extent a confrontation clause objection was made originally, I think that has now been clarified. To the extent one remains to how we anticipate her to testify, that would be overruled. So if there was any confusion there of the ruling, it's to any continuing confrontation clause objection based on her testimony as currently expected.
if she gets into that, Judge, then I need to.
Renew it immediately, yeah. And I do think I'll just give her an instruction here so that it's clear that she needs to listen to the questions very carefully and what it is expected her to be focusing on.
I do want to be clear with the court. As the court mentioned yesterday, there will be cross as to the weight of the things that she used in her findings. So I am going to be asking the witness that you, Dr. Sullivan, perform an autopsy on this decedent. Did you have any time to process this case with hands-on? So, like, did you perform the autopsy essentially? I'm going to be asking her on what she did for it. And I think that there is a line there where she may be tempted to cross into Dr. Henniger's findings as well, but I think that that question is valid to talk about the work she actually did in coming to her findings, because that does go to the weight of the findings. I think that she is okay in saying that an autopsy was performed, but anything beyond that, I think is going to hit that objection that I'm.
Well, look, I mean, if we go down that road, I think it's also potentially fair game for her to say that she peer reviewed that autopsy, but she's again emphasizing that she's coming to her own independent findings without mentioning the findings that were in that original autopsy.
Right.
So, and to the points you raised before, when it comes to the standard of 702, I'm considering the totality of her testimony as presented, knowing that reliability doesn't raise to a standard of correctness and that it's a preponderance standard. The point being is, as I believe that the arguments you were making as to whether her standards fell below that point are ones that go to the weight, not admissibility of her testimony and of her opinion. And so, again, using 702 as a gatekeeping function, based on what I heard, I believe it passes muster. So with that, why don't we have Dr. Sullivan come in and I'll give her those instructions and we'll bring back the jury.
And Your Honor, I think we mentioned, I'm not sure which photos are going to be used with Dr. Sullivan. I never got.
All right. In the interest of efficiency, if we could just go ahead and hand those over, whichever ones you're planning to either admit through her or admit through that she relied on for her opinion. Were you planning to admit photos through her?
I didn't know if I could.
I mean, you're going to know if she can authenticate them. I don't know that.
But I don't think she can. I don't think she can. I was going to need to use Officer Williams. That is a little bit of tricky because he's testifying after her. That's a little bit tricky.
Can you call them limited for that purpose?
All right, but I still think even if you're not admitting them through her, you know which ones she looked at. And so we could at least have that clarified for the defense.
Sure.
All right. I think yesterday she said she looked at about 7. Yeah, I would just get an answer on that.
Your Honor, I do apologize. It's going to take me a minute or so to get those photos pulled up so that I can turn them over.
I mean, you have them pre-marked as exhibits because they're on your exhibit list.
The problem is that the photos that she's referring to are not photos that I was planning on using with Dr. Henninger because they were post-incision photos. That's the problem. I mean, I can pull it, but and I apologize deeply to the court. I don't have those pictures in my PowerPoint. I'll have to pull them in. I know where they are.
I mean, and then presumably these are all turned over to the defense in batch.
They are.
Can you just give us the file names so they can just look in their file?
I mean, they're the autopsy photos, and I can certainly pull them out. It'll take me probably a few minutes just to pull them out and then group email them over if that's. And I apologize to the court.
I was given a minute to step outside. I think they should be given a minute as well.
We can go ahead and have Dr. Sullivan come in so we can handle this.
No.
All right, welcome back, Dr. Sullivan. We'll swear you again when the jury comes back. Feel free to have a seat.
Okay.
We're going to get restarted here in just a minute. What I wanted to make sure I went over with you is that because you're, in essence, coming here in the place of Dr. Henninger, there's a few evidentiary complications we just want to make sure we're all on the same page with, and the rules of evidence are followed. I think the state may have already made this clear to you, but based on your testimony yesterday, the expectation is anything you're testifying to today is based on your own independent assessment, and that you're not repeating or just duplicating whatever Dr. Henninger wrote in his report or what he observed or the findings and conclusions he came to. So if you can just keep that distinction clear in your mind and in your testimony, listen very carefully just to the questions that are asked and answer those questions. And so we shouldn't really be referring to the contents of Dr. Henninger's report unless somehow in the questioning that comes up, and then we'll deal with it. If there's an objection, we'll pause in place. Am I making sense?
I think so, yes.
Okay. All right. Anything further on behalf of the defense on that point? All right. And then just to confirm, Dr. Sullivan, informing your own opinions, did you look at all of the photos involved in this autopsy or only a few particular ones?
During the initial peer review, I looked at all of the photos.
But for your most recent assessment, because that would have been, I mean,
A few years ago.
It's a long time ago. For your independent on more recent assessment, it was just a few of them?
Yes.
Okay. And so the state is trying to pull those now and make sure we're all on the same page of which ones those were.
Okay.
If you need to assist counsel at his table, feel free to do that.
Yes, if we
Starts
could,
out
if we
at
could go through the photos. that Dr.
516,
Sullivan used on the
right?
record as well, and just identify those.
I've got 5.
All right, Mr. Wilson, what's going on?
I'm almost done. I'm missing one more. I should be done very quickly. I apologize.
And Judge, while Mr. Wilson is doing, I just got a scheduling question, see if the state or the court anticipates where we might get closings today.
That's hard to estimate, isn't it? Until we see how the direct and cross of Detective Williams goes, which I expect will be lengthy. And
Are there any other witnesses without the Detective Williams?
no, there weren't any discussed yesterday. Again, I need to have a colloquy with the defendant to see what's going on there. We may get to the state's first opening, and then we'll go see where we go from there.
Pictures have all been sent.
All right.
Do I need to send them to the,
I don't think I need them right now.
I just want to make sure.
If the jury's ready to go, well, let's give it another minute here.
And it's these five, Mr. Wilson.
Should be fine, yes.
Oh, I guess these places.
So-
Too, man. Yeah. Not bad.
Mr.
Pretty
Wilson,
smart, hey,
Yes, sir.
there's what was conveyed to me yesterday, featured something about ligature marks, but there's no pictures of that.
I'm gonna keep it to the cause of death.
Okay, so we're not getting into ligature marks.
That's, not through that, not through Dr. Sullivan.
So I would ask the court's Representative Sullivan to kind of focus the testimony on that as well.
All right.
Should I run through the pictures with Dr. Sullivan and projector before the jury comes in, just to show her what we're looking at, just so there's no.
I'm happy to do that.
If you want to bring her the laptop to show her, you can. And just so we're all on the same page, but just to be clear, I know this may not have made it on the record in an exchange between counsel. It appears the state is just proceeding solely on opinion on cause of death and not as to any opinions on ligature marks.
And the state could also identify the exhibits they're expecting to tender.
I will.
Through detective Williams.
I understand, and I don't think we need to do that at this moment because that's not what she's basing her opinion on. But we'll get to that when Detective Williams gets a little closer. You should already, I think they're already marked.
Just these five. That's what I mean. I mean all of the autopsy photos they're getting approved. Mr. Lynn, I don't think they're getting these photos in through Dr. Sullivan.
I don't think they're getting them in through anybody,
Oh, okay.
is what I understand, because they're post-incision and,
Well, two of them are not, and they would come in through. I'm gonna.
okay.
Go.
Do you happen to have the exhibit numbers for those ones?
I do. No. So.
Or you can just show and just make it clear to counsel which ones, even if you don't have the exhibit numbers, will later be, you anticipate tendering through Detective
I've
Williams.
seen them.
You know which two of the five, then I think we're good. All right.
Okay.
All right. Then with that, let's bring in the jury. Thank you, Deputy Scott. Everyone, please be seated. State may call its next witness.
Thank you. Call Dr. Harry Sullivan.
Swear form of the testimony.
I do.
Can you see? Would you please state the statement?
Karen Sullivan, Karen Sullivan.
And what is your occupation?
I'm the chief medical examiner for the Fulton County Medical Examiner's Office here in Atlanta.
And how long have you been doing that?
I've been the chief since the spring of 2021.
And before that, what were you?
I was still at the medical examiner's office as a deputy chief medical examiner.
What is a pathologist?
A pathologist is a medical doctor who studies the effect of disease and/or injury on a person's body.
And what is forensic pathology?
Forensic pathology.
Let's pause right there. Understood. All right. We had a juror have to step out to retrieve his notes. Everyone is back and present. Stay can resume.
Thank you, Your Honor.
You can continue your answer if you recall a question.
A forensic pathologist is a pathologist who uses external examinations and autopsies on individuals to determine their cause and manner of death.
And could you go through your medical or your, excuse me, your educational background?
I have an undergraduate degree from the University of North Carolina at Chapel Hill and a master's degree in anatomy from the University of Georgia. And after getting my master's degree, I was a high school teacher here in Fulton County for about 5 years before going to medical school at Morehouse School of Medicine here in Atlanta. And then after finishing Morehouse, I did a residency in anatomic and clinical pathology at Emory, and then an additional year of forensic pathology fellowship training at the Fulton County Medical Examiner's Office in conjunction with Emory.
And are you currently licensed to practice medicine in the state of Georgia?
I am.
How long have you been that?
Since residency, which was maybe 1998 or 1999.
Are you board certified?
I am.
And what does that mean?
Well, that means that I've completed a residency and/or fellowship and taken and passed qualifying exams in those areas.
Now, do you belong to any professional organizations?
Yes.
What are they?
The National Association of Medical Examiners.
And what kind of organization is that?
An organization for forensic pathologists, death investigators, and toxicologists and other people who work in the death investigation field.
What is an autopsy?
An autopsy is both an external and an internal examination of a person's body. The external examination is much like you would get when you go to the doctor or take your child to the doctor, looking at a person's height, weight, their body habitus, and any external evidence of natural disease or injuries. And then the internal examination, the doctor is looking at a person's internal organs, again, looking for natural disease processes and/or injuries in order to determine their cause and manner of death.
Now, how many times have you performed autopsies on people?
I've either performed myself or supervised pathology residents and fellows between 3,000 and 4,000 autopsies.
Have you ever been qualified as an expert in any court of law in the fields of pathology and forensic pathology?
I have.
How many times?
More than 100.
And that includes the Superior Court of Georgia, correct?
Correct.
Your Honor, at this time I would tender Dr. Sullivan as an expert in pathology and forensic pathology.
Any other objections other than those than previously raised and preserved by the defense? All right, state may proceed.
Dr. Sullivan, did you have an opportunity to view some photos of the body of Kay Thomason?
I did.
And what photos, what kind of photos have you recently viewed?
Autopsy photos of Miss Thomason.
And were you allowed to view some specific photos?
Yes.
And what did those photos describe?
A sharp force injury to the back of Miss Thomason's neck, and then additional photographs taken with reflection of the skin showing blood that was in the back of Miss Thomason's neck.
And well, obviously let me try this again. Based on your viewing of those photographs alone, were you able to determine a cause of death for Kay Thomason?
Yes.
And what is that?
A stab wound of the neck.
And specifically, I mean, do you have an opinion as to, based on viewing those pictures, as to how she died?
Blood loss because of the sharp force or stab injury to her neck means that enough blood is not available to her heart to circulate to her internal organs, including the heart itself and the brain, in order for her to keep living.
May I just have a moment, Your Honor? Thank you. Nothing further, Your Honor.
Cross-examination.
Thank you, Judge.
Dr. Sullivan, good morning.
Good morning.
Thank you for being here. I want to clear up a few things about your findings. Now, the finding that you just mentioned and this, that the state asked you about, they were careful to ask you that it was based on your recent viewing of some photos from the autopsy. Is that correct?
That's correct.
How many photos?
I believe there were 5 to 7 photos.
5 to 7 photos. Okay. Did the photos include a viewing of the back of the neck of the decedent?
Yes.
Did they include a viewing of any portion of the front of the body of the decedent?
Yes.
They did.
The ones that I viewed yesterday, some of them, yes.
Did they include any view of the internal organs of the decedent?
No.
So when you testified about what an autopsy is, it's an external and an internal examination of a decedent to determine the cause of death.
That is correct.
Okay. But those photos that you reviewed that you're basing your conclusion on didn't include an actual view of the internal organs. Is that correct?
That is correct.
You didn't perform the autopsy in this case, did you?
I did not.
And you weren't there when it was performed, right?
I was not.
To put it in layman's terms, I guess, you were never hands-on with this decedent at any point. Were you?
That is correct.
Okay. So the conclusion as to the cause and matter of death that you're presenting today in your expert opinion is solely based on the photos that you recently reviewed. It was 6 or 7, I think you said, that didn't include any viewing of the internal organs of the decedent. Is that right?
That is correct.
Okay. And despite that, and despite the fact that you weren't there when the autopsy was performed, despite the fact that you were never hands-on with this decedent, as you testified just now, you were able to make the opinion that the decedent died because of a stab wound of the neck
That is correct.
and the loss of blood that follows after that.
Yes.
That's all I have, Your Honor.
Any redirects?
No, Your Honor.
All right, can this witness be excused?
Yes, sir.
Thank you, doctor.
Thank you.
State may call its next witness.
We would call Detective J.T. Williams.
Swear affirmative today, testimony is the truth, truth so help.
Sir.
Please spell your name.
Detective J.T. Williams, Williams.
And where do you work, sir?
With City of Sandy Springs Police Department.
And you said detective earlier. How, have you always been a detective with Sandy Springs?
Sure.
Okay. When did you first start working for Sandy Springs?
July 1st, 2006, we left. I resigned from the Fulton County Police Department with honors as that area had incorporated and become the city of Sandy Springs. So at midnight, we transitioned to the Sandy Springs Police Department.
So you went from Fulton County to state, just folded into Sandy Springs?
Yes, sir.
Is that accurate?
Yes, sir.
Okay. How long have you been a law enforcement officer?
28 and a half years.
And have you been a law enforcement officer in Georgia that whole time?
Yes, sir.
And and you've been post-certified for that whole time,
I
correct?
was certified in good standing with the state of Georgia.
Could you please tell the jury what your experience as how kind of your journey as a law enforcement officer?
In December of 1995, I graduated from Middle Tennessee State University with a bachelor's degree of science and criminal justice with a double minor in psychology and sociology. I came down, applied with Atlanta Gwinnett and Fulton County Police Departments, but was put on hold because of the Summer Olympics, and was hired January 2nd, 1997 by the Fulton County Police Department. I worked the midnight shift for 9.5 years, joined their SWAT team in 2004. And like I stated, in the fall of 2005, the General Assembly passed a resolution to allow the residents to vote if they wanted to incorporate, which passed. So I began police services July 1st, 2006 as a detective with the Sandy Springs Police Department. And I was assigned to the SWAT and crime suppression team.
Do you have like a specialty detective branch that you do?
Yes, sir. I do major felony and death investigations and children cases.
So you've investigated how many homicides?
Oh, good Lord. As a lead or as a second, 20 to 30, but I've been involved in, I get called in for all the murders.
Okay.
And when I first started, we were hands-on involved with all the murders.
And kind of when were you the lead detective in this case?
Yes.
Go through what you think, what your process is when you get assigned to be lead.
Well, you receive the phone call and you inquire into the location and the basic details. When you arrive on scene, you kind of take a deep breath, take it in, and look at what you're dealing with. Are we dealing with one person that was watching a baby in a one-bedroom apartment, or do we have a house like this that's very large and complex? We come up with a game plan. Through all my training, you would come up with immediate tasks, intermediate tasks, and general tasks. And as the lead, you will guide detectives and CSI. It's a teamwork.
Have you, what kind of specialized training have you received as far as being a homicide detective?
I have the GBI basic 40-hour death investigations class. I have homicide, advanced homicide, victimology. I've easily have hundreds of hours of homicide or case studies as well.
Now, on the, I'm going to draw your attention to the 27th of June in 2018. You were working at Sandy Springs.
That night?
Well, no, you were working. You were employed at that day.
Yes, sir.
And where were you that day?
I had left work. It was Thursday, so Thursday's kind of with my life at that time with my daughter and son and my wife. Thursday was our nights to go out to eat because we're in bed early Fridays for sports. And I was in Dawsonville at the Connie House eating dinner, hibachi, when my phone started to ring.
And that's bad.
Yes, sir.
All right. So what happened?
I received a phone call from Detective Sutton, who was informing me of the call. I requested him to respond to the scene and to lock it down. I then received a phone call, I believe, from Sergeant Mizuraka, Misuraca, who briefed me as well. I then called my sergeant, who was brand new. That particular day, we had gotten a new captain and 2 new sergeants in our division. So I called the sergeant and gave him a heads up what was going on.
Was there any question whether or not who was going to be the lead on this case?
No, sir. When we met later, I learned that my partner, Will Johnson, had been promoted and only had 7 days left with me. He was going on vacation. When he came back, he was going to be a patrol sergeant.
Okay,
So it was immediately per command staff, I was going to take lead on this.
all right. So you get about what time did those phone calls start coming in?
Around
You were-
7:30.
So what did you do? Well, you finished.
Apologized to my wife and kids, and we had to hurry up and get home, shower, change clothes, and I responded to the precinct first.
Okay, do you recall about what time you got to the precinct?
I believe it was around 9 p.m.
9 PM? And who did you meet with there?
I first met with Detective Sutton, who briefed me and gave me the logistical information that I needed to obtain a search warrant for the house. So I wanted to get that done.
Why is that important?
We want legal authority to enter the house. We don't know who was living there at the time. We didn't have a clear, we always act in caution. We didn't have a clear picture of what was going on there. So we wrote the search warrant. And also so we can get CSI can start slowly going in and, looking around and figuring out what they need to do, what resources we need.
Yeah, let me ask you this. Based on your position as lead detective and based on what information you had heard from up until that point, what were your priorities? What were your tasks?
First was to get the search warrant, but upon talking to Katie and learning about the email and that there were video cameras, that immediately changed the focus to, we want to find the server in the house. When we can come in, not mess up CSI, we got to find that server and get it immediately and get it worked on.
Okay.
Second would be, we looked at possible points of entry or exit and to preserve the evidence. We were looking logistically. So when we have cases like this, we're focusing on the now, but we have to look 12 hours ahead. Where are we 12 hours from now? So I don't get to the house till around 9:58. Nobody's been to bed yet. We got this huge house, so we're thinking logistically. So we want to do a walkthrough of the house, see what we have, what we don't have, and then come up with a game plan. And that's where CSI Barkley and his team will come into play the next morning. We'll go this far tonight and then place the house under arrest. When you get a search warrant, we have 10 days. So we can literally stay there for 10 days.
Okay. So your first goal is to make sure that everything is methodically processed.
The first goal was to find the server. We wanted to know if the cameras were hooked up to a server, and we wanted to know if we had a live feed or not. Were these just cameras not connected to anything, or did we have a server?
I'm going to show you what's been previously admitted, State's Exhibit number 5.
Yes, sir.
What is that?
That is the front of the house.
And do you know about, when was that photo taken? As far as time of day?
It was in the evening after the sun had set.
But that's the house you showed up to?
Yes, sir.
Now, I'm sorry, what time did you show up on the scene?
Believe around 9 o'clock. Or no, I'm sorry, almost 10 o'clock.
Was there anybody other than Sandy Springs Police Department there when you showed up? Any witnesses or anything?
No, sir. When I went to the precinct, Katie, the kids, and her friend were at the precinct because I interviewed Katie after I wrote the search warrant.
Now, when you got to the scene, what was the first thing you did?
I arrived on scene and I stepped in the incident command trailer. We have a portable, like a big mobile home incident command trailer. I sat down and was briefed by Detective Johnson and Detective Sutton.
And what did you first do inside of the house?
Conducted a briefing in the foyer.
No, I'm sorry, past that. What was the next thing you did? What'd you do next?
I put on a pair of gloves and walked around the downstairs without touching anything, and then went upstairs and just conducted an overall view of the scene.
Why would you put on gloves?
I don't want to contaminate. You have a habit of wanting to touch things.
Okay. And that's important to you that would be important to you as a detective to keep everything
Yes, sir.
as clean as you possibly can.
Yes, sir.
Okay. So let me ask you, when you're walking through the bottom of the house, what if anything do you notice?
I remember the computer monitors on the floor. The back French doors were open. The TV had been picked up by Katie. I went over there and looked at the TV and where the drawers had been opened up. There was some concern about the positioning of the couches or cushions. And the sink had water in it, and it had a copper colored, a little bit of copper colored water tint, which we did a blood enzyme test that was positive. That was an area of interest. And there was a garbage can that contained wine bottles that became an area of interest downstairs as well.
Why is that?
There's a wine bottle sitting on top. It had the foil ripped off, but all the wine bottles underneath had a very methodical little like razor cut around them. And that'll come into play later with the video evidence. But it looked out of place the way the top was ripped off, and it was sitting on top. It was just concerning. It just didn't sit right.
I'm going to show you what's been previously admitted as States 31. Are you familiar with that? You're familiar with that photo, correct?
Yes, sir.
And what is that?
It's one of the back doors.
And what is unusual about that photo?
It's
Or-
missing the locking mechanism.
Did that mean anything in particular to you?
No, I believe Katie had told me that the back doors sometimes were kept open or unlocked, and it looked like there was painter's tape around so they were missing, some of the doors were missing either the doorknob or the locking mechanism.
Now, what else of importance did you personally observe downstairs?
Just that it appeared the room, one of the side rooms had been ransacked.
What do you mean by ransacked?
Drawers opened up, things laying on the ground.
And that's based on your experience, that's unusual, correct?
Yes, sir.
Where did you, after you finished, you said you finished the downstairs, where'd you go next?
I went upstairs.
And where did you go?
I went up to the top of the stairs. I looked left, I looked right, and I noticed there was a door in front of me that had what appeared like a bloody handprint going across, a transfer of blood. I then looked to the right, down towards what will be her master bedroom, and I saw what looked like poop on the, feces on the hallway. So I walked down there and found a dress mirror shattered, laying on the ground, and human feces. And then I observed a purse that contents had been dumped out on a bed. And there was another set of piece of human feces if you're facing the bed to the right. And then I saw the fitted bed sheet had a transfer of feces pushing up. It looked like something had happened there. I then walked back down, just kind of poked my head in a room or two, and I walked over to the bathroom and looked in, but we stayed out of the bathroom until the medical examiner got there.
Okay.
We wouldn't want anybody going in there. There's no reason to go in there. She's been pronounced dead. There's nothing we can do. And then I checked the other rooms as well.
Okay. And before I don't mention it, I'm going to show you an exhibit that's been entered into the record. Now where is that located in the house?
That's Miss K's master bedroom, and that's the Defender DVR sitting under the lamp.
Okay. So that's the server that you're referring to.
Yes, sir.
And tell us what you know about that. What does that mean? What does a server mean? What does that do?
It collects, and if it's recording, then theoretically the footage should be there because the TV was knocked over. So once everything was photographed, we picked it, turn it on, the World Cup's on. But then you hit the AVI, and Channel 5 and Channel 7 came up, and we looked, and you could see one going down the driveway, one going down the back.
So what did that mean to you?
We're recording, and we're praying that we have video.
Okay. Was there anything missing from the front of the house?
Her car
What kind of car did she drive?
was a 2008 Kia
Do you know what model it was?
Sorento, I believe.
I want to show you some pictures and have you describe them as to where they are in the house and what significance they had
Yes, sir.
they played upon your investigation.
So that is the hallway leading into the master bedroom, and that is you can see the feces.
I'm going to try to. Could you please point out where that is in the picture?
This is the dress mirror that shattered, and that is the feces.
Okay. Why is that significant to you as an investigator?
Because it's unfortunately when you're dying or you die, you'll defecate. It's very common. I believe that's where the attack occurred, where it started. I think that's you're getting into a lot of activity right there.
Okay. And this is what does this picture show?
That is a different angle. Again, the feces, the shattered mirror, and another important item is the broom.
I think I've already shown you that. What is important about this picture?
Again, you have the shattered mirror, you have everything's been rummaged through, you have feces here, but this appears to be the broom that she took outside.
How do you know she took a broom outside?
It's on video.
Okay.
When he's in the house, she comes out, she's looking around, and she's holding a broom and she changes hands with it. And she goes upstairs because she's gonna email Katie. So she comes up, she's gonna set the broom there.
Okay. What time did she send that email? Do you know? Approximately.
250 something.
And what is this? What's the significance of this photo?
All of the items discarded, everything ransacked, rummaged through, thrown on the ground.
What is the significance of this photo?
There's more feces here. And you have feces here, here, and then you're gonna have all the transfer and all the push up on the bed. These are the contents of the purse that have been dumped out. And this is now transfer of feces.
Okay.
There's the feces, and again, this the angle, the side.
And what?
And Your Honor, can we ask that we identify which particular exhibit has been referred to?
All right, just for clarity on the record, just as you're showing the photos, if you could refer to an exhibit number.
This is Exhibit 68. Please, could you please tell us what the significance of that picture is?
It's a transfer of feces, but if you're defecating on yourself, it's gonna be on your backside and your bottom. So she's been pushed up onto the bed.
And all of these things. Let's see. I'll show you what's been entered as State's Exhibit number 86.
This is the door leading into where the chair was and the blood and the carpet from yesterday. That's the transfer of blood.
So that is a picture of that door.
Yes. Yeah, appears to be a handprint.
I'm going to show you what's been entered as State's 81. Please describe the or explain the significance of all things that you see as an investigator on that picture.
So if you come up this top of the stairs and make a left, that door that we were just talking about is going to be right over here, going into that room. You have a Revlon cuticle tool with blood on it here. You have a bed sheet that was taken off a bed down the hallway and across. You have blood droplets here. You have a transfer of blood here, smearing, directional. You have a bathrobe here. And then you have her feet. And if you'll show the other one, there'll be fecal matter on the feet where she stepped in it. And you have a partial shoe impression. Now it's not a mold of, it's not the shoe on perfect sand or wet concrete. It's because the blood is around the tile, but you get an impression of a shoe, just the side of it.
I'm going to show you what's been marked as states exhibit, as states exhibit 134. Please take a look at that picture. Is that what you were talking about?
There's a closer up, there's a more detailed.
That would be 136. That's enter.
Yeah, there's still another one, but yeah, you can do that.
Can you use that one? Maybe it was not. Perfect. Enter.
Yeah, that can work.
Okay.
We're both 136 and 7.
Okay. What is significant to you as an investigator on that picture? In that picture?
Two things. You can see there's a stain of fecal matter on the heels, and there's ligature marks around the ankles, and bruising, contusions.
Now, did you take an inspection of Miss Thomason's body? Did you or look at view her body, I should say?
Absolutely.
Okay. And what did you notice about her body?
She was bruised from head to toe.
Okay. And did you notice any significant injuries to her?
Yes, she had a void on the upper part of the neck, a hole in the back of the head.
Okay. And was there blood loss?
Yes, sir.
Okay. And can you kind of go from head to toe? And just name the significant injuries that you saw on her?
There's bruising and contusions everywhere. There's a cut to the lip. There's ligature marks on the ankles, the right humerus area has a lot of contusions, a lot of sign of trauma. Obviously, the hole in the neck. There's bruising to the feet where it appears if she was confined or zip tied, where they're pushing up. It's just bruises everywhere. But the right humerus was very, very concerning, and obviously the stab wound.
Now, after you did an inspection on her body, what did you do? What did you kind of do next in the process?
Well, actually, before we did that, once the medical examiner got there, we methodically went into the bathroom and collected the items before we approached the body.
What items?
The cuticle tool, the fitted bed sheet, the bathrobe, and then I believe we did a tape lift of the tub. Because when the transport company gets there to remove a body, a lot goes into this. You have to walk in, you're gonna have to pick up, you're gonna have to lay a body bag down, they're gonna have to lay a towel down. So we're bringing in a lot of evidence that I don't want in there. So we processed that. That was that night. That was the only thing that we took, was right there, the intimate stuff in that bathroom. And then the body was taken out where we examined it with the medical examiner's office.
Okay.
And then we placed the house under arrest. I believe I left around 2:30 that morning.
And where did you go?
I went back to the precinct and we had a meeting, and then I went home and slept for a couple hours because I was going to the autopsy. But I had been notified that CSI had obtained a video footage of the defendant walking up the driveway, going around behind the house, going in, the victim would come.
On the grounds of?
The reference to the defendant.
Oh, I see your point. Okay.
Could you just say an individual? Would that
My
clean it
apologies,
up,
ma'am.
Judge?
Okay, so sustained. If you could redirect.
So you were mentioning that you saw an individual on a camera.
Yes, sir.
What was that individual doing?
He arrived at the bottom of the driveway where the person stays for about 20 some minutes, then walks up the driveway, goes around behind the house, unscrews the porch light.
Again, I'm going to object. If there's video of it, it should have been shown to the jury.
All right, on those grounds, that'll be overruled.
Thank you.
It's called best evidence rule, Your Honor.
Understood.
Was it now? Did your department take custody of videotapes that were made depicting the outside of 1095 Old Woodbine?
Did we take?
I mean, did you download? Did you get video surveillance?
Yes, the server was downloaded and video was successfully obtained.
Okay. And that is referring to the State's Exhibit 506, Your Honor, which is their surveillance video. I'd like permission to publish. Well, I guess it's in evidence. I'd like permission to publish it.
Is it possible to, when the lights are on this video, if it's dark, you're missing a lot of detail?
Hey, can we dim?
I
the
mean, if
front
we
of
could
the
almost
courtroom?
just turn the light, unless,
Hold on.
All right, we will dim the lights again as we did before.
Thank you. Could you let us know when something of significance happens and explain it?
Can you make it a little bigger, spread it out?
Sure.
And remove the stuff from the side.
That's fine.
I was talking about just left and right. I wouldn't go zoom in any. Just, that's fine.
What is that?
The suspect or a person?
Again, whenever we're presenting the videos, if you could just note the time marker.
That is at 1 minute, or excuse me, 52 seconds of the video.
Then you're gonna see some lights from a flashlight.
And much with respect, it's for the jurors to see what they see.
Understood, Ms. Levinsky.
Do you notice anything unusual about the person that's depicted in the video's appearance?
There's a towel over the head,
Well, anything.
a baseball bat in the right hand, and there's massive sweat stains on the jacket.
Okay.
And a two-way radio on the back. What a pic.
Your Honor, I repeat, it is for the jurors to see what they see, not for this witness to tell them what he sees.
All right, so members of the jury, I'll just instruct you as I did at the outset of this trial. You are the ultimate arbiters of any findings of fact as you choose them. This is the witness is testifying as to his opinion and his characterization of the evidence. You can choose to accept or reject that. And so with that, you can proceed, Mr. Wilson.
Thank you, Your Honor.
Mr. Wilson, and Your Honor, I'm now going to ask for the jurors to be removed. There's something we need to take out up outside the presence of the jury.
Yes, Mr. Wilson, is anything that's been displayed something you have has not been admitted or something you do not plan to admit
No,
on the side panes?
there is there is nothing that I don't plan to admit through this witness.
Okay. Then at this point, I don't see a need to break. We can you can lay the record of anything you need to at the appropriate time.
Your Honor, with respect, that's not correct. There were side panes, and what was on that side panes is objectionable.
I do plan on admitting those those pictures and the evidence through Officer or Detective Williams.
Okay. Then we'll take that up at the point of admission. You can renew your objection then, Ms. Lubinsky, and if I need to create a curative or limiting instruction at that time, I will consider that. You can
Maybe I
proceed,
should-
Mr. Wilson.
Thank you. Maybe I should go ahead and do that right now.
You can present the testimony in the manner you see fit.
Yes, sir. Can we have the lights back on? Thank you. Detective Williams, did you, yeah, did you observe, you said you woke up to go to the autopsy of Kate,
Yes, sir.
and were you there during the autopsy?
The entire thing. Yes, sir.
And could describe to the jury how that all worked. Where were you?
430 Prior Street. You come in the front, you sign in, and then we go into a briefing room. There's usually a briefing at 8:30, and they go over past cases and what cases are on the table for that day. Not to be morbid when I say table, but what's on the agenda, what cases they're declining jurisdiction, accepting, so on and so forth. And you then find out what doctor is going to do your autopsy. I've known, and then you go into a side room and you put on booties, you put on an arterial gown, gloves, head net, glasses, and a surgical mask.
So you were actually in the same room with a doctor performing autopsy on Kate Hollis.
I'm standing right beside him.
And were you able to view everything on her body that the doctor pointed out and everything on her body that was observable to you?
Yes, sir.
I'm gonna maybe take a look at these exhibits number 45 through 514 and ask you what those are and if you're familiar. Please look through those.
Yes, sir.
What are those?
They're pictures from the autopsy.
Autopsy of who?
It's the picture, I'm sorry, it's the pictures from the K. Thompson autopsy.
And are those fair and accurate representations of the body condition of Kate Thompson when you were viewing the autopsy?
Yes, sir, they are.
Your Honor, at this time, I'd ask that states 45 or 45 to 514 be admitted to evidence.
I think we're gonna need to clarify because that would be 460 exhibits as you've described it.
Oh, I'm sorry.
45 to 514,
I meant to say 485.
485. Okay. All right.
485 to
514 inclusive?
All right. So to 485 to 514. Any objections?
no, Your Honor.
Those are admitted.
Thank you.
And wasn't 514 that you previously admitted, as well as 511, 512,
It was.
513?
I'm gonna have to readmit those numbers.
All right, 506 through 515 is already taken. So I think you need another 9 numbers.
Yes. And that would be 516, I believe, through 520 at the end.
Well, I mean, you've also already admitted a 498, a 499.
Okay.
Got that track. It starts at 560.
Your Honor, at this time, what was the number that you had? Start there and just go
Five,
from
I've-
there.
I've-
515.
I've got 516, 515 being license plate photos.
Okay, so 516 we would begin at.
Well, let's go with our court reporter,
16.
perhaps. That's 515. Okay.
16.
So that means 516 would be the next one. Yeah. All right. So to confirm, 516 is our next available state's exhibit number.
Okay, so that would be 516 through. That'd be through 546.
All right. Those are now going to be renumbered and referred to as state's exhibits 516 through 546. There haven't been no objection to those previously. Those are admitted. We'll renumber those not on the jury's time.
Oh, no, I understand. I'm just putting one on the back. So
Okay.
Detective, when you attended the autopsy, could you tell, Could you tell all the injuries that she had? Were there other injuries that you didn't see at the scene of the?
Well, that
Judge, I'm going to object. This witness is not a medical examiner. He's not a medical expert. This is not his role.
All right, the question was just whether he observed any injuries. It's overruled.
Thank you.
there were 2 lacerations to the throat where the Adam's apple is, the larynx.
I'm gonna show you, hand you what's been marked, well, admitted as 519.
Yes, sir.
Does that describe those?
Yes, sir.
After you finished watching the video, how many times, when the video that we referenced, how many times did you see a suspect appear in that video? Total.
Up the driveway, around back. And then in. Then she'll come out. She'll go back in. She'll go out. And then she'll come back out finally,
What do you mean by shill?
the victim K.
Okay, thank you.
And then he'll come out at one time walking. Then he comes back in. And then the 4:43 time, he'll come out again. And then there'll be, I believe, one more time he'll come out where it looks like he's carrying a laptop under his arm.
Okay, and after you reviewed that, what did you do next in the investigation?
We had a meeting with everybody. We had a lot of resources conducting the canvases in the area. We had a meeting and we had a bolo put out for the motor vehicle. It's a be on the lookout. It's a poster with a picture of a Kia Sorento. It was already on NCIC, GCIC is stolen. And we believe I came in, I interviewed, been Friday. There were some leads were starting to, like, a gentleman had came to the house and sprayed for mosquitoes earlier in the day. Things were starting to be revealed with the video, such as Timothy and Miosha Bryant, just people that were there, things like that.
And so when you see those sort of things as lead detective, it's your responsibility. Is it your responsibility to follow up on those things, or at least have somebody?
They are. So you'll task them out. Eventually what'll happen is tip line and our criminal intelligence unit will take in all of the tips that come in. They go to the commander and the commander will assign them out to a detective to be looked into.
And what is how much after the date of incident is this occurring?
Within a few days, because I guess the next immediate goal is we wanted to find the vehicle.
Okay, when did that happen?
So we had a meeting with Katie and her brother, and we were able to get an iPad out in a Mead notebook because Kate kept changing her passwords, or kept changing email addresses because she was forgetting her password. So she had like a book with a log, and Brad was able to go in her iPad and get into her Google account. And eventually, I believe it was 11:13 Friday night.
I'm going to object to any hearsay information that was obtained from somebody named Brad, who has not testified in this court.
All right. And so, Mr. Wilson, if you can make a questions and if there's specific out of court statement that you're offering for the truth of the matter asserted.
I'm not necessarily
that.
doing that, Your Honor, because I think let me,
Why don't we just direct it with a specific question?
sure. Were you able to get information on the location of a Google account or the Google account of Kay Thomason?
Yes,
And how are you able to do that?
it was obtained through her Google account.
I mean, how does that happen?
He hacked in to the,
Well, I understand. How do you figure out what the location data is? Did you do that yourself?
no, sir.
Yeah.
It showed, so the other key thing is we don't know where her phone is. We can't find her phone. And the phone records show that her handset goes dead, I believe, at 5:08 p.m. on June 27th. Same thing with the other phone. When you ping, it's not a ping, it's a command to locate. When you command to locate, sometimes you can't get within 13, 1400, 1600, it's in meters. So we had this giant area where this phone could be. We had no idea where it was.
Okay.
But we were able to be guided to near 4900 Peachtree Road, which is Discount Tire. And
Did you personally go there?
several times, not that particular day, but once that 4900 Peachtree Road kind of came up, that gave the street crime guys kind of a geographical area to push out both north and east and do a methodical grid search, which is what McCabe did and found the vehicle.
Okay. Do you recall what date that was? How long was that after?
It was
The incident?
Friday, and I received a phone call from my commander, Captain Spears, around 11:13 or 11:15 at night. I just got home. He called and informed me that they had found the vehicle, that they were going to set up and do surveillance. I was going to come in, but due to the significant amount of hours and lack of sleep, he was like, "Go to bed, leave your phone on ring. We'll call you if we get somebody." So I got up the next morning and learned that they had impounded the vehicle to a fire station and left a patrol officer with the car all night, and that it was going to be processed the next day.
Did you go to that processing?
No, sir. I went to the apartment complex where the vehicle was located and assisted in the canvas.
And what did you find anything?
Through
Well,
the,
Actually, let me withdraw that.
Yes, sir.
After you did the canvas, what did you do next?
we went back to, after the canvas, we go back to the precinct and we start looking at the tip lines and things like that. I know we were getting ready to do a press conference with the family.
Okay.
The city had offered, the city had approved $100,000 reward. So we wanted to do a press conference with the family, get the information out and see if we could drum up any leads.
Because right now, at this point, you did not have a suspect.
No, sir.
How long ago after the event was this?
The press conference?
Yeah.
It was, I think, within a week. It was in, I think, the first week of July.
And did you follow up on leads based on information that was coming in?
Some of the leads, yes, sir.
Did you, now, did you start to develop persons of interest
Yes, sir.
in this case? How did you do that?
The tips that were coming in, the first person of interest that came up was kind of 1 and 2 at the same time, but we'll deal with the first one, was Prentice, Prentice, Jerome, Jerome, Brooks, Brooks.
And when did you learn of his potential interest in this case?
We had released the video of the subject walking up the driveway. when we did the press release. And we were getting a lot of phone calls from people calling in saying, hey, I think I saw somebody, may know, may not know, things like that. Prentice name came up a lot.
Okay.
So I knew of Prentice Brooks. I had never arrested him before or dealt with him directly. I knew he was a local homeless guy. I knew he had braids at one point, not as long as on the video, and he's a big old guy. He's huge. He likes to hang out in parks, so he can use grills and covers and stuff. So we had the tips come in on him. We researched him, and we found him in Chastain Park, talked to him. Basically, he's like, take the swabs, do what you got to do, and get out of here and leave me alone.
Okay. And how long ago was that conversation after the incident?
We found Prentice Brooks pretty quick, I believe. I think we're still in July.
Who's the next person of interest you talked to about this case?
Sean, Shon, Randall, Randall, Holt, Holt.
And how did you know, what was Mr. Holt's connection to this?
Sean Holt is the victim, Kay Thomason's handyman. Sean is renting a house on McCaslin Street, I believe, and he was in apartment or house A. Across the street was one of Kay's rental homes. Sean had met Kay down on McCaslin Street, and she was using him to do kind of the handyman fixer up stuff for both that rental property and the rental property she had on Hemp Hill. Now, I had interviewed Sean Friday, right after the murder, to see if he knew anybody that possibly had braids like we saw in the video, to which he stated he didn't. And we kind of just met and talked, and I gave him a card. I was like, listen, if you get any information, let me know. So we learned that Sean has a crystal methamphetamine addiction. And we got text messages between Kay and Sean from the Google account where she's threatening to call his bond officer. So we started kind of looking more into Sean.
Okay.
And what we realized is he was arrested in October of 2017 in Jackson County, Georgia, I-85 North exit 137 for various traffic infractions, drugs. Well, his sister will make his bond. I believe Dane Baucom, a roommate, Dayne Baucom, was with him. His sister makes his bond. Now, fast forward 1 month later, same officer, monitoring same traffic, sees same guy drive by, checks him, suspended. This time he has crystal methamphetamine, marijuana, obstruction. So he gets arrested again a month later, and they seize his van.
So did you investigated Sean Holt?
Yes, sir.
What did you do as the detective to follow up on Sean Holt?
We interviewed him. We did search warrants on his past phone, current phone, and we got his DNA swabs.
And did you have any success based on those results?
None.
How many other persons of interest did you have at that time?
There was Brandon McDonald.
And were you able to eliminate him at some point?
Yes, sir. We got his DNA swabs as well.
And were there any other ones that you knew about?
We also, our investigation led us to a gentleman, Brian Fromm, Fraum. We got his buccal swabs. And then after interviewing the Bryans, we got Timothy's buccal swabs as well.
And how long did it take for those, or how long did it take for those, all that processing to take place?
Months.
Okay. And you had no other suspects or persons of interest?
There were tips that were coming in, but it was nothing viable.
What happens, what do you know, what do you do next in regards to this case?
We spent a lot of time going through boxes of paperwork. We basically had locked myself in the conference room for weeks at a time and just go through all the handwritten notes. She kept a lot of records, and we're going through and we're coming up with a database of phone numbers. We had done cell tower dumps, which are search warrants for the cell towers that utilize the geographical area of the house. That was, I don't know how many nights I spent walking the apartment complex, walking up and down the area by the Chambly MARTA station and backing around. Found a brand new townhome over there that had cameras and went to the HOA, and they're like, thanks for letting us know we weren't recording.
Okay. So
Just massive canvassing, going through financials, documents, and just following up on different leads and tips.
So this is, several months have elapsed,
Yes, sir.
and you don't have a lead at this point?
Correct.
At that point? When did you finally get a lead? How did that happen?
With the Google search warrant.
Yes. What did you do? What did you do on that?
So I learned from CSI Sawtell that he came back from a conference and that this technology was available. So
What
And-
technology?
to be able to give Google a latitude and longitude and give them a perimeter to see if any devices were present.
Okay.
So we got the latitude and longitude from the house, from the front porch, and I drafted the first Google search warrant, and that would be in March of 2019.
Okay.
Oh, and there's also, there's several meetings with the GBI were going on as well with evidence. There was a lot of looking into what evidence we had and what we were going to do with it, and some meetings with the GBI.
And was that working to a successful conclusion at all?
No,
Well, to be specific on the Google data, when did you finally get the Google data?
it was 6 months after, so it would have been in October, I believe, 2nd of 2019. The raw data for the 7 devices comes in.
And when you got that data, what did you do? Could you please explain well, no, actually not. When you got that data, did that allow you to develop some people of interest?
Yes, sir.
And Your Honor, this is now becoming a repetition of the testimony of Jane O'Brien. And I think when we start reading
Okay. Depends on how much time we spend on it. So for now, a 403 objection is overruled. You can continue, Mr. Wilson.
Thank you. Excuse me. Based on all the Google data, you were able to develop a suspect on that?
Yes, sir.
And what else did you use? Google data? What else did you use to develop a suspect on that?
DNA,
Okay. And what else?
the Google searches.
And what were the Google searches from which Google account?
James Jones.
And were any of those searches important for your investigation?
Yes, sir.
And which one?
He had Googled her address June 20th of 2018. And the night of the murder, approximately, well, as he's en route there, he uses Google Maps. He plugs her address into his Google Maps.
At the stage, I want to object.
Is this again, you're saying 403 cumulative? All right, overruled.
And I don't have anything regarding it.
You're saying that you don't have the Google data?
I don't have anything showing that you will arrest.
Mr. Wilson?
It's in the Google data that we delivered to their office twice.
Okay, we'll take up any discovery concerns at the appropriate break based on that representation. You can continue.
Thank you. Now, after you found out where the defendant, all of that information about this defendant, what did you do next?
Once we identified him,
Yes.
We
Well, how
can-
did you identify him?
the phone number, we were able to run it through law enforcement search engines, and we realized that he had re-upped his driver's license March of 2020 using the 404-838-3782 number. So it's attached to his official Georgia driver's license.
Let me approach, let me approach it with, Marcus States 5.7. Are you familiar with that?
Yes, sir.
What is that?
That is the Georgia driver's license and GCIC inquiry for driver's query for James C. Jones, birthday April 7th, 1996. That's
And
the
what does it have listed as an address?
3630 Clubhouse Circle East, Apartment D. David, Decatur, Georgia, 30032.
And this has a phone number on it?
Yes, sir.
And can you tell how long that can you tell a minimum date from when that phone number was active with that defendant's account?
2011.
Okay. And let me
Uh,
ask you a question. Let me offer that into evidence first. Offer states 5.7.
That's already been admitted as an autopsy photo. 527.
Which is the last number? 546.
So you're now in 547.
547, that's what Your Honor, state would offer 547, states 547.
Any objection to 547?
No, Your Honor.
547 is admitted.
And the person that is, do you recognize that person?
Yes.
Is that person in the courtroom?
Yes, sir.
Could you please point that person out and identify that person by an article of clothing that they are wearing?
Person is seated between counsel with the glasses, the braids, the white shirt, and the black jacket.
And who is that person known to you?
That is James Jones.
Your Honor, at this time, I'd ask that the record reflects that the witness has identified James Jones.
The record will so reflect.
Thank you. Which one is the Warner video? Watch it. That's okay. I just have one moment, Your Honor. Thank you. Nothing further for.
All right, members of the jury, I think we've reached a good stopping point. So I would ask if you could be back, let's just say, I don't know if there's a preference by show of hands. We could say 12:50, just so we stay on track. If that works, a little less than an hour, but should be enough time. Please don't discuss the case with anyone, including amongst yourselves, and don't do any research about the case. And so unless there's any concerns, we'll see you back at 12:50. Thank you. All right, Detective Williams, you can step down. Please don't discuss the case with any witnesses while you still remain, as on the, in essence, on the stand.
Yes,
All
Your
right.
Honor.
Anything to take up with the state before we break?
Your Honor.
Anything on behalf of the defense?
The Google search document. That
Okay.
I want to see this Google search document.
Okay. I mean, it's in the data.
I want to see the document.
Okay, we'll get it for you.
Is this part of the data that was tendered as 499?
Yes,
So you're saying, okay, you're saying it's in 499 as an exhibit.
they're from Google. You have to kind of parse through. I mean, we've already did.
Okay, if you could just put your finger on that, show where it is on exhibit 499. To that end, just so I can plan the afternoon, I want to go ahead and give you a tentative charge packet I can work on over the lunch break. But to make sure I've considered all the issues in that, I think I need a preliminary inquiry into the defense, whether they plan to present any evidence at this time.
Maybe have a few minutes to discuss that.
Certainly. Certainly. And this is, I'm going to have a colloquy with your client. This is just a general understanding, so I can go ahead and give you a tentative charge packet. And so feel free to take some time or take a few minutes just to give me an initial reaction. All right. With that, we'll be in recess until 12:50. We can do that off the record. You can just give me a thumbs up or thumbs down, and we'll go from there. All right. We're in recess.
What are you looking for? I'm looking for you. I'm looking for the.
I just couldn't find it. I didn't want to look.
Yeah.
I think maybe I
Was it a surveillance video I missed? What did he say about the Google search?
What are we doing? Keeping track of all those exhibits?
No, I just remembered we stopped at 5:46.
Yeah.
And then yesterday he gave me 5:15, so that was the last thing I saw.
I didn't know if you knew when they were the date.
We Googled it, you can pull up the thing, and show it.
Why not? That's what I mean. You're not.
Did you show him do it? You remember how to do it?
No, but I want to.
I used it on Monday. I used it.
But no, this is more than just using it. It's going out the gate.
No, I came up.
That's not what they're talking about. They're saying,
Not getting it. Type it 2 fingers. You're not a pecker. You know how to do it.
Oh. Oh, time to go. Can you?
Anna's emailing it right now. We were not.
Judge, can you hear me?
Can you hear me, Judge? Or Ms. Vortis or somebody in the back?
Yeah.
If you can let the judge know that at this point, we're not planning on putting up a case.
Okay, thank you.
Jenny?
I'm not the one that screwed up all the damn. I'm not the one that screwed up all the damn exhibits. You did that. Yeah, you did. I know you. I had that old PowerPoint. You changed the numbers on me.
Did I? I thought I was doing it based off your numbers. I did. Did I? That's been the choppiest part about it. 597, 571.
Yeah.
Oh, man. I'll take it. Or is that 511? That looks like 511, right? 511?
Yeah.
Did she email it?
I'm gonna-
Okay. She's emailing it.
Who? Seen it. I've seen it.
Yeah, I think I printed it. I think I did print it. It should be at the.
Oh.
Say mailbox.
Yeah. What are we working on?
That's kind of damn Google.
She said,
Oh, I think it's already in here.
well, I'm sure it is because we got all the stuff before. But I just don't like, but she said it. So. Where's the number?
On the side. On the side. Could be on the side right there. Hmm?
You have them?
No, not yet.
Yeah, wait on Janet.
I understand.
What you said, that's the work.
I know, I know.
I'll wonder.
I think that's you.
Oh. No.
Rough draft instructions on a verdict form.
Did it go to Mr. Fawcett?
Not sure if that's this.
Yeah.
Sorry, Judge, nothing.
That's fine. I'll make sure we send it again if we didn't send it originally. All right, we're back on the record. All parties are present. Mr. Wilson, following up, were you able to direct the defense attention to where in 499 these Google history searches are?
We're printing them out, Your Honor. They're on, oh, we're in 499. We're printing them out. I don't know exactly. We've got them, so we're printing them out.
Is this just a PDF?
I don't know that it is.
It's your exhibit. What is it?
Well, I'll need to look at it, Your Honor. I don't know exactly what format it's in because I've got so much stuff here. I'll look at it very quickly. Is that from 499? That's from the Google apprentice exhibits.
That's what Investigator Bryant said.
Okay. I don't know where 499 is.
I think I put it back up there. I'll check. So here are the, here's the activity report.
Okay. This is from State's Exhibit 499, Your Honor. And I mean, it's voluminous, but
All right. And so can you direct us?
turned over.
Understood. And so can you just point a finger somewhere where this search history appears that was alluded to earlier?
Right here.
All right. When you say right here, you're looking at, was that the third or?
Yeah, about third or fourth page.
Okay.
And then fifth page goes on, and then it goes on with the activity history. So it's like all of these pages have activity history.
There were two Google searches referenced specifically in testimony, Judge, one on June 20th and one night of the alleged incident. Then for 21st. But I think there was one or two specifically directed, and then they got on the record for testimony. So those are the ones that we wanted to.
Okay. Well, you've got the records they are pointing to. I have not seen them, so I couldn't tell you what's in them. But they're saying that's the basis for this testimony. All right, let me start with the state. Is there any reason we can't resume and bring out the jury?
I don't believe so, Your Honor.
Anything on behalf of the defense to address?
No, thanks.
All right, it looks like the jury is ready. Thank you, Deputy Scott. Welcome back, members of the jury. Please be seated, everyone. At this time, defense may conduct a cross-examination of this witness.
Thank you, Your Honor. And Detective Williams, I think you said that when you arrived at the house, one of the back doors was open.
Yes, ma'am.
Can I assume that that was the result of police activity?
I cannot testify to that. I just know it was pushed in. It was open about that much.
It was, but you don't know whether it was like that when the police arrived on the scene or not.
No, ma'am, it's just how it was when I got there.
Okay. But you did find that the doors were missing handles
Yes, ma'am.
and there was tape over the receivers.
Yes, ma'am.
So that doors could not actually lock.
Yes, ma'am. I believe it was blue painter's tape.
And did you actually find kitchen or doorknobs in the kitchen drawers?
Yes, ma'am.
And you did not see any signs of forced entry.
No, ma'am.
And you also did not that night see any zip ties in the house.
Correct.
And you did not see a door standing on its own upstairs.
Yes, ma'am. There is a door, but it's in a cardboard box. And if you go up the stairs and go to the right, I remember it was like not in the way, but there is a door. And it's in a big white cardboard box. We have a picture of it, and it's just sitting up there.
Now, you have a very competent Georgia Bureau of Investigation to which you sent items for DNA analysis.
Yes, ma'am.
And the GBI had run suspects for you through True Allele.
Yes, ma'am.
And I would guess in all the years that you have worked with Sandy Springs and with Fulton County, you've used the GPI many, many times.
Yes, I've also used another private lab once as well.
And then in March 2019, you take a whole lot of evidence to DNA Labs International.
Yes, ma'am.
Why?
We had a meeting with GBI with Stephanie Fowler and Jim Sebastian. He's the director over the entire DNA unit. They told me, you were essentially asking me to shut my crime lab down for 3 months and test all your evidence. They explained to me that they had items being tested right now that were going to trial next week. There was over 40,000 sexual assault kits in backlog. They told me they would not test the victim's dress because it was underwater for 12 hours. I had to fight with them to test the fingernails. I had to fight with them on various things. And when I found out they didn't test the other set of fingernails, we had a meeting with command staff and we got permission to start freelancing and looking because we had used another private lab in another serial armed robbery case. The GBI could not get any profile, but that private lab got it, which got a guy was wrongfully arrested by the FBI out of custody. I am not going to be told no when I have this type of a case. And to me, that was unacceptable. And we're gonna look elsewhere.
So would it be fair to say that the GBI had concerns about the reliability of any information or any DNA profile they obtained from an item that had been underwater for a period of many hours?
That was one thing. We wanted the fitted bed sheet upstairs where the fecal matter stains were. We wanted that MVAC'd. That is a little vacuum cleaner, little handheld little guy that sucks out and takes the profiles. They said, no, it's too expensive. They said, we'll take that fitted blanket, we'll hold it up and we'll do alternative light source. I can do that. And then we'll MVAC that area. I said, no, I want the entire bed sheet MVAC. No, it's too expensive. Okay, we'll pay for the filters. You can't do that. They didn't test the fingernails. They didn't want to test. And then here's the other thing. The turnaround time is unbelievable. It's months and months and months. And their rule was, you bring us your 5 best pieces, we'll work it. If that doesn't work out, then you bring us your next 5 pieces. We'd still be testing right now.
They did, in fact, test the fingernails, didn't they?
One side. Because she was right-handed, they didn't do the left hand. They talked about how expensive the test was we were wanting done, but we knew GBI had the MVAC, and it was frustrating. And in that case, I'm not going to accept no as an answer.
So how much did you pay DNA Labs International for their work on this case?
Don't quote me. I think it was around 114,000.
114.
Don't quote me though, but it was somewhere between 112, 113, 114, I believe.
Now, you had, let's see, gone through from the inception of your investigation, you'd gone through a number of leads, correct?
Yes, ma'am.
And you investigated a number of potential suspects.
Yes, ma'am.
One of them was this gentleman by the name of Sean Holt.
Yes, ma'am.
And Sean Holt clearly had access to the house, did he not?
Yes, ma'am.
He'd been in the house many times.
Yes, ma'am.
And he was also somewhat upset with Miss Thomason.
Yes, ma'am.
He was angry. She wanted him to work off the money he owed her.
Yes, ma'am.
And he didn't like that awfully much.
Correct.
And he also lied to you a number of times.
What we found later was I believe when we interviewed him at Habersham County Jail, he was sober and had been sober for weeks. When you talk to him when he's sober, he clarified a lot of things, but it appeared at the beginning that he was lying. He did lie to me about the meth use, but the other things, he's methed out all the time. So it's hard to communicate with him and figure out what side of the spectrum he's on.
He also lied to you about when he'd last seen Miss Thomason, correct?
Correct. But when I confronted him with that, he got all upset that he forgot. And he says, he explained to me, I forget things, this and that. He can't keep up one day versus the other when he's geeking back and forth on meth.
In November of 2019, you obtained a video enhancement that played the video on a frame by frame.
Yes, ma'am. I was on vacation and I received a phone call that they were testing a program called Input Ace. And while they were trying to run it frame from frame, that an image came up where they thought it could possibly be a white male.
So they thought it could be a white male who was wearing a disguise.
Yes, but we learned later with Input Ace, as you said in opening statements, her DVR is not the best quality. And when we used Input Ace 6 months later on another murder that I worked, that witness had impeccable state-of-the-art digital video. And when you used Input Ace, it was horrific what you saw, the graphics and the details. Input Ace with her pixels and the speed, her system's is borderline VHS tape quality. So I never bought into that. I notated it, that it was said, that it was mentioned, but I never that theory.
Did it ever strike you as a possibility that the braids could be a disguise?
It was discussed, but no, not the way they were pulled back and the way they came down the back of the jacket. I didn't believe so.
You didn't think so, okay.
No, ma'am.
Did you ever learn that the house at 1115 Old Woodbine was vacant?
I believe it was being remodeled.
And was vacant?
Yes, ma'am.
And did you ever check to see if there were people in and out of that house?
One of the detectives did. They learned, I think they spoke with them.
I'm not interested in what
I did not, no, ma'am.
But that would have been interesting, would it not?
No, ma'am.
No. 1115 is one house away from 1095, correct?
Correct, but I'm concentrating on 1095, not 1115.
But this is one house away and it was vacant. And you don't know if there were people in there, correct?
To my understanding, the house was secured. It was being remodeled.
So you'd gone through Sean Holt, you'd gone through a number of other potential suspects, and I think to say you had looked at something close to or more than 100 tips as I read your police report.
Yes, ma'am. I believe it was 132 tips.
And you had nothing.
Correct.
And you were pretty much at a standstill.
No, ma'am. We never quit. That was the philosophy. That was the attitude. If there wasn't anything else critical going on, I never gave up on this case. I would always go back and walk around the apartment complex. I would even go sit at her house and eat lunch sometimes and walk around. I would, I never quit. I mean, like I said, I took boxes and boxes out of the house later with the family's consent. And we spent weeks and weeks and weeks just going through financials, paperwork, writing down numbers, things of that sort.
But your investigation was bringing up nothing.
Correct.
So you come up with this geofencing warrant.
Yes, ma'am. After Keith Sawtell came back from training, he sat me down in the conference room and walked me through it. And then we went over the verbiage and what was required.
And one of the things you had to do in order to obtain a warrant was sign an affidavit, correct?
Yes, ma'am.
And I assume what you put in that affidavit was the truth.
To the best of my knowledge, yes, ma'am.
And in support of your application for the geofencing warrant, you stated that the suspect came out of the house at 4:43 a.m. talking on a cell phone with his left hand.
Yes, ma'am. He comes out, he has a wine bottle in the right hand, he's taking a swig. Now, you can't see the phone, but it appears he's holding something up to his ear. I believe that to be a cell phone. But you can't say it's a cell phone, but yes, I most definitely.
And that was really the basis for your geofencing warrant.
No, ma'am. The phone just has to be on. For the geofence, you don't have to be using it. It just has to be on. We were going to do that regardless.
And you had watched that video many times.
Yes, ma'am.
Now, when you got the Google location information regarding the device 125882190, did you notice that the device had no location information after 3:14 a.m.?
Later I did. Yes, ma'am.
What do you mean later?
So that morning, because of COVID, I was working from home. Four worked from home, four stayed at the precinct, four had to work at a offsite location. I got up that morning, observed the email, and my office was set up in the bedroom. So I tiptoed over there and started playing with the coordinates, but I called Jen and gave it to her. And then I learned later that, yeah, the device is stagnant from that time that y'all talked about yesterday.
And you would agree, would you not, if the device was, you call it stagnant?
We're off. Yes, ma'am.
It's off.
Yes, ma'am.
It could not have been in use at 4:43 a.m.
Yes, ma'am.
In fact, would it be fair to say that based on the Google document, you had no idea, the Google location document, you had no idea whatsoever where that device was between 3:14 a.m. and 5 a.m., correct?
You would have to opine because of the video and the car hasn't left yet that it's just off, but it's still at the house. There's no other logical explanation.
Unless that's not the device.
It's the device.
You know.
Yes, ma'am.
Okay. So then you obtain information for an hour before and an hour after.
Yes, ma'am.
And you obtain that information without a warrant, correct?
Correct. In that part of Google, you have 14 days to give them the two device IDs or the device IDs. So in this case, we submitted K's device ID and the device ID ending in 1290.
And then you obtain a search warrant.
Yes, ma'am.
May I have one moment, Your Honor? What was identified as the murder weapon?
The cuticle tool?
Was James Jones' DNA found on that item?
No, ma'am.
I have nothing further for this witness. Thank you, Your Honor.
Any redirect by the state?
Your Honor, I do have either, I may have to recall him really briefly to publish an exhibit that I didn't play during my direct examination. If that's.
When you say recall, he's here.
No, but.
You want to cover additional ground?
Yeah, yes, Your Honor.
All right.
But it'll only take like 5 minutes.
And this is just to play an additional video?
Yes, and it's already been edited and everything. So
All right, I'll allow that, and I'll also allow defense counsel to cross on that point as well.
thank you, Your Honor. Detective Williams, Your Honor, this is from Exhibit 507. Did you view a MARTA video?
Yes, sir.
And are you familiar with the contents of those videos?
Oh, yes, sir.
And what do those videos show?
Shows that
Well, I mean, just what descriptions?
arriving at a train station, getting on a train, getting off at the Chambly station, walking in and out, carrying a bag.
And are those all contained in a combined
Yes, sir.
presentation? I'd like to publish that now, and that's all from.
May I have one word with Mr. Wilson?
Sure.
Footage from the house.
No, it's just the MARTA stuff. Your Honor, it says that I can't share.
If we could have Mr. Wilson added as a co-host to our Zoom conference.
I assume I'll get an alert when that happens.
All right, you got it.
Oh, it's good now. It's good now, Judge. Thank you.
Please take off the side things.
I am.
Please take off the side things.
I'm trying to.
Please take them off now.
What is going on?
But I'm not sharing now.
Yes.
But I did take off. I need to hit that right when it's shared.
Slideshow animation. Because you need to do so. You need to hit the slideshow animation when you get it sharing. Let me see. Let me see it.
I mean, can I take this off?
1 second. There you
Okay,
go.
perfect. Thank you, sir. Thank you.
Your Honor, I'm going to object.
Okay. On the grounds?
This is what I specifically asked Mr. Wilson about.
But is it, you're gonna have to drag that out for me. I don't,
Your Honor, can we do this outside the presence of the
all right. Is the issue that he is displaying exhibits that have not been admitted?
No.
Okay. All right. There's the jury. If you can step out. All right. Jury has stepped down. What's the basis of the objection, Ms. Slinsky?
Mr. Wilson said he was going to play the mock, and perhaps we should do this outside the presence of the witness.
I don't see this, unless it's affecting his testimony, and it's just we're talking about exhibits. I don't see a need for that right now.
Your Honor, Mr. Wilson said he was playing the martyr video. I understood him to be playing martyr video. This is not the martyr video. This is the police compilation. And I specifically said to him, it doesn't include the footage from the victim's home. And he said to me, no, it's the martyr video. And what this is in fact a compilation prepared by the state of video footage from the martyr and the victim's home. It is not the martyr video, and the way it is prepared is particularly prejudicial.
How?
Because it is prepared to show certain things. And that's not what was being played, and that's not what was going to be played, and that's not what I agreed to being played.
Okay.
Nor was this ever admitted as such.
So 509 was
What I
previously
understood
admitted?
was being admitted was martyr video footage,
Okay.
which I have received from the state. Martyr video footage. This is not martyr video footage. There is a difference.
Okay, I do see that there are title screens and that sort of thing that don't make it look like it's the raw footage. Mr. Wilson.
Your Honor, it was a compilation of stuff that was all contained within the exhibit, except for the brief titles, so to speak.
So is this when you say it is a compilation, that means it is not the
Well,
exhibit?
it's edited. It's edited for time.
I understand that, but it is not the exhibit you had previously admitted.
It is part of that exhibit, Your Honor.
I understand it's different components of it, but you're saying there's a new video that you edited and you're now displaying and that sort of thing. Or did you actually admit the thing that you are publishing?
I did not, because it was totally contained within the MARTA video.
The title slides and that
No,
sort of thing?
no, no,
So it's
no.
a new product. You're showing a new product to the jury that has never been admitted. I'm not saying it's, that's just not functionally how we should be doing that. But
And Your Honor, it's not contained in that exhibit because footage from the house
right, but the house is admitted through another exhibit.
contained
Okay.
in that exhibit, unless I'm imagining things.
All right, but the house footage comes from another exhibit. The state has pieced those together into another exhibit, which they should have tendered as a separate exhibit. So, Mr. Wilson, you can either lay the foundation, if you can, for this separate exhibit before you publish it to a jury. If it's, I mean, you're saying it's composed of footage that has already been admitted, then I suppose that makes it a demonstrative rather than its own separate exhibit. But you should be explaining that before you publish things to the jury. Are we all on the same page?
I understand what the court is saying.
Unless I'm missing something here, because I don't know the exhibits as well as y'all do.
No, I understand, Your Honor. It was just the portions from the MARTA, and the only thing that was added were the brief.
Were the title slides?
Yes.
Right.
Yes, that's it.
And some from the house.
And I shut that off immediately.
Okay. Did you have any additional
No.
components of this you're publishing?
No.
Okay. All right. So from here, you still have some other matters you're going to redirect him on.
That's it.
You don't have any other further questions for redirect?
No, Your Honor.
Okay. Were you planning on recross?
Say anything further.
No.
Okay. Do you expect some questions for recross, Ms. Levinsky? Okay. So when the jury returns at that point, does the state have any additional evidence they expect to call?
No, Your Honor.
Then let's use this time. I want to proactively have a colloquy with the defendant in anticipation of Let me ask this, Ms. Levinsky. Preserving your ability to make every motion you need to do it when the state rests, instead of bringing in the jury just for that split second, would you be willing to make a preliminary announcement that the defense rests before we hear your motions?
Your Honor, as things stand, it looks as though we will be resting.
Okay. What I'm just saying is functionally, I'll bring them back in here. The state will rest, you'll rest, and then we'll hear motions you may have as it regards the state's case in chief. Is there any concern about that?
I will make a pro forma motion.
Okay. Do you have any concerns about the order that I do that in, though? That I just have you rest? And that's all I'm just trying to make sure is that the order of things. I'm trying to prevent them to come in here, sit down for 2 seconds, and then leave again. Okay. So I have to have an exchange here back and forth with the defendant directly. And so this is going to be a series of yes or no questions. And just let me know if you need any more time to consider this or to consult with counsel. Don't need to stand, however, whatever makes you comfortable.
I apologize. Can Officer Williams step down?
I'll let you say nothing further and nothing further over here before we have him step down. Do you understand that you have a right to testify? And if you want to testify, then no one can prevent you from doing so. All right. Do you understand that no one can make or compel you to testify? That is, you have a right not to testify if you do not want to. And do you understand that not your lawyer, but you personally are the one who decides whether you will testify or not? Do you understand that if you do not testify, then upon proper request, I will instruct the jury that that decision cannot be used against you? Okay. And if you choose to testify, though, you'll be examined by your counsel and cross-examined by someone from the state. Do you understand that? Do you need any additional time to think about whether you want to testify? And do you personally want to testify or not? All right. I find that the defendant has decided to not testify with a complete understanding of the rights involved. Thank you. So with that, let's bring in back in the jury, and we'll go from there. Thank you, Deputy Scott. Please be seated, everyone. State may resume their direct examination.
Nothing further, Your Honor.
All right. Any recross on behalf of the defense?
Thank you, Your Honor.
Can this witness step down, Mr. Wilson?
Yes, sir.
All right.
Thank you.
State may call its next witness.
Your Honor, state of Georgia rests.
All right, members of the jury, at this time, the state has concluded presenting evidence in its case in chief. As I instructed you at the outset of this case, the defense is under no burden of proof whatsoever, and they do not have to present any evidence. So with that, though, they do have the opportunity to. Is there any evidence on behalf of the defense?
No.
All right. So with that, then, members of the jury, the evidence in this case is closed. And so I now have to have a conversation and a meeting with counsel that we confirm what law applies to this case that I'll instruct you on before we can begin closing arguments. I do think we will begin closing arguments today. I can't say for certain that we would conclude them today because each side is allotted a certain minimum amount of time they're allowed to use. So I would suspect we will begin closings. I would say no later than 2:30, possibly earlier. So we do still have some waiting time here, and I thank you in advance for your patience, and we'll keep you updated. I wouldn't leave the building and don't go far, and we'll let you know when we are ready to begin closings. All right, thank you.
Here.
All right, any motions on behalf of the defense in light of the state's resting? Floor is yours, Ms. Lubensky. I said floor is yours to make your motion.
Your Honor, there is no evidence upon which a reasonable jury acting carefully can convict. I will leave it at that.
All right. Let me ask the state this, count 8, value of the car.
Yes, Your Honor, we're going to go ahead and ask the court to enter null pros on that count.
All right, we'll have that reflected.
Thank you.
And would you be requesting that the jury may not remember that that's a count. I can instruct them to disregard that, or we can just leave it at where it is and redact the indictment. You tell me.
I've always said count 8 has been removed or
From your consideration.
removed from your.
And we leave the indictment as it is, and we'll give them a verdict form that just goes 1 through 7.
Removed from your consideration.
All right. So is this, I guess I would be formally, I don't know, granting a null pros, or am I granting a directed verdict on count 8? Is there a,
We would ask that it be phrased as a null pros because it is a request from the state judge.
all right. But in terms of the instruction of the jury, I'm just going to tell them that count 8 has been removed from their consideration. All right. So with that, then, I believe we would be ready to move into our charge conference unless counsel needs to address something else or there's anything else to talk about. You should have been emailed now a compilation PDF of all of the requests as well as other ones that that I thought might need to be included and applicable. Okay. And just for purposes of the record, so we're following along, I'm going to mark a copy of that 48-page document as Court's Exhibit 1, and I'll tender that. And what I thought I might do here is simply tell you some of my inclinations based on the packet as I present it to you. And then I'll just turn it over to the parties to address in bulk. We can zoom in on specific things if we need to. So perhaps that might be easier than going page by page and asking for objections for each individual charge. And so you can lodge those in the specific pages you have concerns about in bulk when I turn it over to you. So just I'll go through it with the notes that I have. On page 3, the presumption of innocence, I struck the line because it didn't appear there were any affirmative defenses presented. So there's a strike through on page 3 where it talks about the presumption of innocent pattern charge. You'll see a strike through on page 3.
Where a defense is.
That's right. I believe that refers to affirmative defenses, so I didn't think that was applicable here.
That's, thank you.
All right. And then I'm just going to keep as long as I'm looking at pattern charges, I'm just going to keep turning until I see something I want to note or highlight. Actually, I'll do this. On page 6, it looks like I should also strike through the parentheticals talking about stipulations. We don't have any of those, and we don't have any judicial notice issues, so I'll strike through those. Page 7 is stipulations. I'll just strike that entirely. I don't remember which party requested it, but I have that on there. On page 8, state requested the short version of direct and circumstantial. And that's fine. I'll include the long version for that. For page 9, credibility of witnesses, I struck their intelligence. There's a case from the Court of Appeals that says we should avoid that if possible. And so I have that there. And again, I'll just turn this over to y'all to say in bulk whether you have other specific objections so I can spare y'all needing to weigh on each one.
Problem to the removal of the words their intelligence.
Okay. All right. 11 and 12. Witness impeached and intact, supported. We're zooming in on character, lack of bias, criminal convictions, those sort of things. I didn't see that as applicable because we have on page 13 the catch-all of how you impeach a witness, disproving a fact they testify to. And I don't know if I saw these specific avenues of impeachment being used. So I had tentatively struck that. On page 14, I did include the pattern on prior statements, as I think there was some reference to that. On page 16, I tailored defendant's choice not to testify to just focus specifically on the fact that the defendant has chosen not to. Again, I struck 17, 18, and page 19 because they didn't come up and they're not applicable. From here, it's all pattern charges. We get to 25, which was state's request for party to a crime, and I didn't see that as applicable here, so I was planning to strike that.
That's fine.
Malice murder, I tailored to strike the parentheticals because I don't think this implicates an affirmative defense. I also struck on page 28 the state's request for premeditation, as the note to that pattern charge tells us we shouldn't be given it unless requested by the jury. I've tailored felony murder to the underlying offenses alleged. And then we get to the defense request on voluntary. And I'll just go ahead and let you weigh in on this, Ms. Levinsky. My reaction was that it was requested by the defense, but under the slight evidence standard, I'm not seeing that here from what's been presented.
Judge, we do not know what happened in that house. So on that basis, I think perhaps nobody knows what happened in that house that night. So perhaps on that basis,
All right.
ask for that.
Position of the state.
Well, Your Honor, I don't think it's an appropriate case for an involuntary charge. There's no evidence of anything that, there's zero evidence of anything that would lead to voluntary. Zero.
All right. Well,
Confused. I think it could confuse the jury, Your Honor. This is a murder case.
well, and involuntary manslaughter is equally a murder case, but I mean, the standard is slight evidence, any evidence. And I think it has to be based on evidence presented, and certainly while we may not know the exact sequence of events, I haven't seen anything presented that would suggest that this was a sudden, violent, irresistible passion, the circumstances within the house, the evidence that suggests what might have occurred. And so we'll preserve the objection for the record, but I don't believe that's justified by slight evidence. On page 35, I need to specifically say in deciding whether a knife, because I believe that's how it's alleged in the offensive weapon and defining it.
It's not a knife.
Oh, excuse me, sharp object.
Sharp
I'm going to make that sharp object. That's right. So we'll just say in deciding whether a sharp object is an offensive weapon. Thank you for that. Okay, and then again, I've got it. I think I've tailored false imprisonment to the exact allegations of the indictment, just detention. Same with, we've got the burglary and intent to steal, and then I'll just strike entirely based on the state's dismissal, page 39, page 40, about theft by taking. Next note I have is 32, verdict generally. I think I'm going to start striking this charge since I'm giving them a verdict form, which will guide them of how they're supposed to fill it out. And I don't think that this charge really adds anything if they're provided a pre-filled out verdict form, which we'll get to in a minute to see if you have any input on that. So inclination is to strike 42, that pattern charge. Not from burglary. Yeah, exactly. That stays connected to the burglary. And that takes me to the end, other than the pattern charges. So with that, let me first turn it over to the state to address anything and everything that I've highlighted and noted in this compilation packet.
I do agree with most of the requests looking for the grave suspicions instruction.
It's included. It was a defense request, and I do understand the case law on that is that it can be considered duplicative of the standard for reasonable doubt. And it's not necessary to give it. I should consider it on a case by case basis. And in a case like this, where I think I'd be inclined to give it.
Okay, Your Honor, that was exactly what I was gonna, those are my reasons for asking you not to give it, because it's not necessary. It redefines reasonable doubt and it's not necessary.
Yeah. Noted. Anything else from the packet?
I don't see anything else, Your Honor. Everything else looks right.
Then I'll turn it over to the defense. Anything and everything you want to address in here?
Verdict generally. The reason for having it is that it should say commit each of the offences as alleged in the indictment, or at least that's the way I've always done it. Commit each of the offences to make it clear that each offence is to be considered separately.
No question about that. And we'll divide it out one by one on the verdict form.
It is divided out, I believe, on the verdict form.
I've just now kind of taken the position here that this is designed, if they're back there on a piece of paper writing out their own verdict, and when we provide them a form, it makes this somewhat redundant.
I still think it belongs in for what it's worth.
And it does give more detailed instructions. I think Your Honor may be right in the sentence, in that event, the form of your verdict would be, we the jury find the defendant not guilty. I think that sentence is fine to strike, because they have the verdict form they're filling out, but the other directions are more specific and aren't listed on the verdict form, regarding the date, regarding each offense.
Okay. All right. Well, I'll do that. We'll bring it back in. I'll strike the last sentence where it says in that event, and from the first paragraph.
Judge, the malice murder charge.
Let me finish this thought before we move to that. So we're going to strike the sentence in the first paragraph that says in that event, and in the second paragraph we'll strike the last clause that begins in which event, and we'll just include the other language. All right, turn into malice murder, which is on page 27.
Why is without justification, without excuse, and without mitigation?
That was, I thought those would be implicated if there was an affirmative defense raised.
So, Judge, I believe that is what is required in the pattern charge for malice murder.
All right, so you would want all those parentheticals included?
Yes, Your Honor, without justification, comma, without excuse, and without mitigation.
Any position of the state?
Your Honor, I don't think it should be in there because I think it's confusing, Your Honor. It brings in kind of a quasi-affirmative. This is an identity case. It's not a affirmative defense case.
Well, I'll say that that's their primary, that they can request alternative defenses.
I understand.
There has been no request though for any kind of self-defense, justification, excuse, or mitigation. Well, I take that back. There's been a request for voluntary manslaughter, but I've denied that request. But I see those parentheticals as addressing that if those were actually elsewhere in the charge, and otherwise we're introducing new terms without any context.
Your Honor, it's still got to include, at the very least, without justification. At the very, very least, it is the unlawful intent to kill without justification. It should include that. it should, I believe, also include without excuse.
And that, I think, falls, tracks the statute, Judge, I think.
All right, I'll pull the statute in just a minute here and take a look at that, and I don't think it's based on the charges on the whole. I don't know if it's material, but I'm happy to err on the side of including that. Other than that, anything further?
Isn't it charged on DNA?
There is, and there's a pattern charge, and it's in here on page 20.
On the murder charge issue, Your Honor, there's a question of implied malice that's discussed in the statute and notes, which talks about provocation, and justification by reference as well, so. When I say it tracks the statute, the exact text of the statute doesn't mention justification or provocation, but notes on implied malice do. So.
Anything further on the part of the defense based on?
Yeah, we might overhear stickers. Do that to me again. I'm gonna be coming after you. Sunday, I thought I had written one out based on your most recent. Did you read that?
All right, so I'll include rather it is the unlawful intent to kill without justification, and hearing nothing else, I will consolidate all of these into one sequential charge without the headings. They'll also receive a copy of this, and I'll have that marked as a court's exhibit as well. Turning to the verdict form, I know we need to eliminate count 8, which, by the way, I'll add into the introduction that that they're not to consider the previous charge of has been removed from your consideration, the previous charge of theft by taking. And that should play no role in their deliberations. I'll work on the phrasing. But turning to the verdict form, any position on the verdict form from the state?
No, Your Honor, obviously with count 8 removed on the form, but that's it.
All right. Anything on behalf of the defense to the verdict form?
Again, with count 8 removed.
All right, then I believe that would complete our charge conference. We'll work on consolidating that and having that document to you here soon. Does the state intend to present the opening closing?
Yes, Your Honor.
All right, and are you using a PowerPoint for that?
Yes, Your Honor.
All right, I'd say feel free to go ahead and get that set up. And then how much additional time would you be asking for just to
Well,
prepare and get your notes straight?
you still planning on starting at 2:30?
I'll ask them if it depends on how much time you're about to tell me you want to get ready.
Maybe 10 minutes or so.
Okay, so I would see if they're ready earlier and I could ask them, but also on the part of the defense, I would say on experience, the state's first opening is 30 to 45 minutes, which would put us at a point where I think that if I'm doing my math right, that would give you your full 2 hours potentially before the end of the day. And so, do you need additional time to get your notes straight and that sort of thing?
I'd like a few minutes.
Just tell me how many you need.
That half an hour will do.
All right, and let me make sure I'm doing my math right. If we start at 2:30, that'll put us a little past 5 if you use the 2 hours, but I think that'll be all right. As you notice, the clocks will come back, and just to keep you mindful of your time, should you need to use all of it. And
Now, for that, I appreciate the clocks.
understood. Okay. Anything else we need to address then?
No, Your Honor, not from the state.
Okay. All right. I'm going to come back I'll come back out here at about 2:25 just so we can start getting them to gather and letting them know. And from there, we'll begin closings.
You know what? I don't care. I'll move that.
I'll get the giggling out the way, explain. Kind of wrap it up.
Okay.
If you don't want to, I can just say something. Just let me know. You decide not to. Either way.
It doesn't matter. I'm good.
I like the way you close things out. Yeah, that's what I'm saying. I like it. I think you kind of learn from you, man. I think I got the biggest issue.
I still show my damn age comes to work on technology or something.
Well, I tell you what, I was going to email it to you, so. Oh, you can put that. Yeah, you can put it back. Thank you.
Okay, so we're good.
I meant to send this to you so you could give me some input, but I guess you'll be surprised like everybody else, right?
Well, no, I got a few minutes.
Okay, I'll email it to you. It's not like you can do anything right now. The biggest issue was organizing the counts with the.
Did you put the exhibits on those?
I have not yet. That's what I'm fitting to do.
That's what you're attempting to do?
Yeah, that is.
I'm gonna email you my updated one to see if you can.
I gotta find that pile though.
I put it in order. It's
I know, I just gotta find where it is.
It's ready.
Oh, is it the ones where I changed the back one? No.
Well, this is all I have.
No, I know, but these are yours. I pulled those away. I stole things.
So these are good attorney. These are good. These are the ones you put in order?
I put them in order. We're gonna do everything all at one time, but I know those were the most jumbled up, so.
Okay, no, I found the stack. That's the one I have to renumber.
Oh, okay.
Because somebody messed up my numbering system.
I'll take it. I'll take that one. Yes, sir. I'll take it.
Ain't no thing.
I think I deserve.
think?
I think I deserve a burger this weekend. Yeah, I'm gonna get me a burger. Maybe some ribs or something. I'm sending you the,
I don't care as long as it has bourbon involved.
yeah, that too. I sent you the email, exhibit list.
You don't need any, you need any stuff, right?
Uh-uh. So I'm sending you the exhibit list and I'm gonna go ahead and send you my PowerPoint. Take a look at it. Let me know what you think. Not like you can do anything about it now though, but you know, can't do nothing about it.
Oh.
You say what now? What you say?
Oh,
Oh, yeah. I'm not gonna do any I'm not gonna do anything shocking. Yes, I don't think it. Oh, no, you should.
You know, we didn't hear.
I had planned on doing that.
For closing, you should. I was just saying like right now, I think they just saw it then.
Yeah.
But, okay, yeah.
All right, I'll stick one. All right, I'll do that.
I forgot. Shit, it's the war. Gotta win.
You're right. You're right.
Yeah.
You're right. All right. I'll do one. The most important one. Cause of death.
Yeah.
Don't you think?
I'll show it now. They right behind.
FYI, the mics are still hot.
Oh,
Yeah, we're not gonna say anything too bad.
No, you did. You didn't talk about us.
No, and then, I know that.
But just FYI.
I
No, I
appreciate
love
that.
being here.
I was about to go into
I
it.
love being here.
Okay, well, we have next week.
I don't love it that much.
Oh, that was good. Good call. I appreciate that,
we
Ms.
all-
Ortiz. Thank you very much.
Yeah, as long as the other side is.
No, just a YouTuber.
Yeah. Yeah. Here, this is conversation.
So we got that one. Cause of death.
Yeah.
Okay. Let me make sure that we're going right here. Using ones at the end.
Yeah, they're all
Okay,
in.
sorry.
Didn't we enter all of them? Yeah, I guess you did. Yeah, we entered all.
We just gonna share that. Okay. 519. Okay, so maybe 519. Where's the big stack at? Oh, okay.
It's up there.
This one. Yeah.
Yeah, I do. I do. Okay.
Oh, I gotta make sure I didn't. Okay, I did that. Mhm. Okay. Okay, okay, I got it. Yeah, I'm saying autopsy.
That's cool. That's cool. Yeah, that's off of my feet. That's what makes it great. Yeah. It is.
Yeah, I gotta find this one.
Did she join the reserves? Did she join the reserves?
She did?
I think she did.
Where?
Oh, with us. With us. I think she joined the reserves. I think she did. No, it was on. I can't say for sure.
Oh,
I think she
okay.
did. Yeah, oh yeah.
And that, when we get it down to.
Yeah, big pop is on.
Works. Yeah.
Yeah, I gotta. You can't hold the cab, can you? How long are you there? 6 years. And they came over here?
That's 6 years.
I did 10 years at mine.
Finally?
Then I came over here.
So your whole career been long. Your whole career been long.
Yeah, and law enforcement, no, that's, no deal on that. No seal on the deal. All straight line.
Hey, is Lieutenant Lee here today?
Huh?
Lieutenant Lee here today?
We left early, so.
Yes, sir. You got, sheriff letterhead paper? Letterhead paper?
On my flash
Oh,
drive?
yeah, computer or something?
No, I ain't got it. I need to get it.
So I gotta get it to him. Oh, but she get it.
Who's really point? We got it, but we don't know nothing. Not the hamstring side. Something really might go up there, man. Yeah. Did it pass? I don't think it's gonna pass. Income household, 1,600 a year, while the richest household would be 12,000. They said this morning, some Republicans don't want it. They said this morning on my news feed, with all the chaos we had going on with America, all the foreign countries, now turning to China and Russia for economic. With all the chaos we had going on in America, all these foreign countries, we had diplomatic relationships with. They're coming to us, they're going to China and Russia. They're saying the hell with America, we're going to China and Russia. We get all our economic help. I said, wow, that's crazy. Yeah. You know, like, this started like, it's like that. You know, they had a president like 20 years ago, it's been, yeah. See, I don't care about somebody. Right. I just care about me and my family. That's essentially what we got. And they say, yeah, they was trying to, it was in the news feed. So, then they talk beeline and patch it up on. So, or he was playing with the coup. He was playing the coup. I think he was playing the takeover. They got word of it. I think he's playing the takeover. No, you can't. Trump got 71 million followers. You can't. It's gonna take a lot to be 71 million. Everything is still on and everything else. That's a lot of followers. 71 million followers. Wow. Military and his wife and my other, hopefully that means he had wine, second. Oh, this is a bar? So, this is all. Really? That's what you can do all that. Yeah. I like Sonic. Like, South the screen. This is. Yeah, wine, they got coffee, and pastry. Go in there and do homework. Hey, I like little atmosphere like that. Yeah. So you want to be comfortable, quiet.
Sure, if I said, good, I think a little device right there.
Yeah, something like that. That's good.
You were looking for it?
No. That's, but I appreciate it. I will leave stuff, you know.
Yeah, coffee carts. I set up in the lobby. And set up coffee. Man, people buy coffee all day. Yeah. I'm ready for this stuff. I'm gonna see that in Google. Still inside the bank. Okay, on my car. I had gourmet sandwiches and everything. Did you really? You got a picture of your car? You should go down to the park, man. Take your car and go down to Piedmont Park. I had so 30 past go ahead. Really? I had. That's what I had 20. That's 20. When you was in New York? Oh, yeah. Really? It's in the spring. You should put your car. You should put your car on the street, like on the corner. Or in the section, professional. I don't want to be. I want to be 800. I want to be 800 foot traffic. You know, people occupy. Just around. You don't want to pay the nothing. It's like that's how I'm I would know. Young man back then. That's it. Yeah. She didn't have monster. She was the water for life. She was. And I remember her having the same day, like, he was a master police officer, license chick, she was police officer too. Yeah, license chick. She was sort of like, her husband, sort of, but she was a main recruiter, but she's just the recruiting investment. And I think her. Sure, but sure, in the tag, right? Somebody over there. What do you think of Susan?
I've lost 20 pounds to get ready for this trial. I haven't, this. About this in 2014, so 29 days trial at Schwarzburg. Better remember where I got it. Feels good to get back home.
Yeah, before I came here, I was on fit. I worked for the FA Federal Aviation, especially for them. I wore suits and ties every day. Bow ties, matching handkerchiefs, matching socks. I am sorry, bow tie.
Sound like you miss it. Sound like you miss it.
I do. I really look. I like get up in the morning time, my own bow tie. Make sure I have matching socks and handkerchief in the pocket. No. You won't be like I miss it. I really do.
Because.
Oh,
You wanna go back?
Oh, I'm going back. I'm going back in the street.
When?
I can go next year. I'll be 6 o'clock. 6 or 7. 6 or 7 years. Have a 5 year. Look, go back to the face. Yeah.
You know, way down there.
You got mental this time?
Yeah, I'll take that.
6 tight.
What's that?
6 tight. Can't sit here.
I'll switch with you. Thank you. Thanks. So what's he planning on doing? Having us argue, charging them and then sending them home?
Like, we might be doing the second post in the morning if she takes the full hours.
Plum.
But I was hoping they have a full day, so looks like they'll get that.
Yes.
Yes. Yes, please.
Thank you.
All right, here's a copy for you. I think it's,
Just send me the. I'll send you the, she sent me.
It's printed.
Yeah.
It's warm.
you want to give him a heads up? We're about ready.
All right, I got you.
I'm in here, but just us.
You don't have patience.
Yeah, you know, you gotta fight. Of course you
Oh, yeah. You don't think he likes that?
You really gonna say that? He likes it.
No, most of the time I don't know what I'm gonna say. Yeah. I'm being honest with you. Most of the time. That whooped my ass. All right. Got a little cool.
Water bottle, please. It's, you know what?
All right, we are back on the record. And for the purposes of the record, I've marked as Court's Exhibit 2 is the consolidated charge, which I would plan to give and also to give them a copy of. And the parties have been provided a copy of that as well. Is there anything we need to take up on behalf of the state before we would bring in the jury?
No, Your Honor.
And who is making the first opening?
I object.
Okay. All right. Anything on behalf of the defense?
No, thank you.
All right. Do you also have any kind of electronics or anything we need to make someone a co-host for on the Zoom?
Yes, you are.
Are you already a co-host? Okay. Just want to make sure we're all clear there.
I don't know that on the post. Hang on, I'm on Zoom. Let's Zoom.
All right. Then I'll direct Deputy Scott to bring in the jury when they're ready. And actually, for the record, I don't think I did this, but as to the motion for a directed verdict raised by the defense, construing all inferences in favor of the state, I do believe that that should be denied for the remaining counts 1 through 7.
Go get him, Tiger.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, we are now ready to begin closing arguments. The state, because they have the burden of proof, has the ability to begin the closings. And I'll remind you what I instructed you at the outset of this trial, which is that the attorney's arguments are not evidence. And then when it comes to remembering what evidence has been presented, that we rely on your memory for that. And so with that, Mr. Fawcett, is the state prepared to begin?
We are, Your Honor.
All right. Floor is yours.
Thank you. Good afternoon. One thing that we tried to do during the course of this trial is to try it in an efficient way. I think we met our goal within the time frame, but I will admit I did not try a perfect case this week. Although I think you should always try to be as perfect and error-free as you possibly can, especially for a week as important as this. We have the duty as a state prosecution office of trying to hold persons accountable when they commit crimes. We investigate, create, and develop proof. And we also, as a criminal justice system, have an obligation to create a system and execute that system in fair and well. And that's what this is a bit about. I will say that I have been a prosecutor since 2005, and I have seen a lot of criminal investigations. I started out in Carroll County for about 10 years. And here, I went to camp. Now I'm back here. And that gave me an opportunity to see a lot of different police departments, and in every county, there are excellent officers and departments, and there are departments that probably leave a little bit to be desired. When I look at the investigation that was conducted in this case, I don't feel that way at all. I truly believe that Sandy Springs did everything they possibly could. And I think that they put a diligent amount of effort into evaluating the tips that came in. I think they put a diligent amount of effort in not giving up. June 2018. Wasn't arrested until 2020. I am the deputy of the cold case unit, and I have rooms of cases that are unsolved. So this case, it means a lot to this office. It means a lot to Sandy Springs Police Department. I'm gonna talk about what was presented this week in the course of my opportunity to talk to you. This is already. I will talk about what the evidence was this week, and most importantly, the distinction between two different types of evidence and some of the inferences drawn from those 500 and something odd exhibits that we tendered into the course of this week. The judge is going to charge the law and the indictment. The judge is going to tell you that you are now considering counts 1 through 7 in the state's indictment. Count 8 with no longer be under your consideration for the offenses of murder, felony murder, aggravated assault, false imprisonment, and burglary. Judge is going to instruct you on your duty as jurors, and simply fairly evaluate the evidence and to follow the instructions that the court will give you. You're bound by those instructions. In your consideration of the evidence, you should consider certain things, and you should not consider certain things because they aren't relevant for your consideration on the determination of guilt or innocence. You shouldn't consider television, public opinion, dislike of the system, sentiment, penalty, punishment, conjecture, or disagreement with law. You should consider the elements of the which are contained within the charges themselves, which you'll get in addition to the indictment. You'll get the judge will give you the law within the indictment. That contains the charges that the state is required to prove throughout this week. So when we are charging in the indictment and you see malice, which I'll go over later, we have to prove what the intent of the defendant was. When we prove that, when we charge burglary, we have to present evidence that someone entered a residence with intent. Those are elements. That's what we've been putting up evidence. That's been the purpose of the evidence that we put up. The entry, the forced entry, the rummaging, the broken glass, the pulled out drawers. All evidence of those crimes that we charged. You also consider your oath as jurors, facts of the case, the testimony of the witnesses, credibility of the witnesses, evidence as presented, the defenses. Major defense in this case. Really, the only defense in this case is identity. Who is it? How do we prove it? The truth and common sense. Judge is going to charge you on what reasonable doubt is. State is not required to prove the guilt of the defendant beyond all doubt or to a mathematical certainty. Reasonable doubt and doubt of fair-minded and impartial juror honestly seeks truth. The doubt based upon common sense and reason is not an arbitrary or vague doubt. Common sense. Basically, when you walked in to this courthouse on Monday, your life experience, the things that intuition, when someone calls you and tells you that they have a, what's the email thing? I'm an ambassador and I've got 3.5 million. They say those emails, you've got common sense. You know, that's ridiculous. So when we present evidence that is cheap with swabs, and we present the range, and we eliminate the suspects, get his phone, track his phone, track him from Gap County. Ms. Thomason's residence. We see evidence in the residence of zip ties. Well, that's a very specific thing because we know from the photographs, from the testimony that Mr. Thomason was restrained. You know, there were ligature marks, evidence of struggling. As she was tied to that chair. Not just tracking him, but looking at where his phone was positioned around the residence, 1095 Woodbine. And when they searched him, when they found him at the U-Haul facility, and yet it's not just about the DNA, it's not just about the Google records. There's additional evidence that I'll go over and talk about the distinction between direct and circumstantial evidence. The Marta video, walking, some big, long, oblong bag, very distinctive. Same bag that we showed you from the U-Haul facility. Zip tie at the location, 1095 Woodbine, same type of zip ties.
Objection, Your Honor, assuming facts not in evidence.
All right, members of the jury, I will instruct you that you are to recall the evidence and base your verdict only on that evidence. You may proceed.
We'll see evidence. The testimony was that there was evidence of ligature marks on the person of Ms. Thomas. They found zip ties in the walkway of Ms. Thomason's back residence.
Again, objection, Your Honor, facts not in evidence.
Testimony of J.T. Williams.
All right. Mr. Fawcett, if you just want to refer to where you believe that evidence was presented, you can proceed.
So the testimony of J.T. Williams, lead detective in this case, testified as to the location of zip ties. Those were items that were collected in the property report from the receipt from the collective evidence at the residence of Ms. Thomas. And photographs from the U-Haul facility.
No, Your Honor, with respect, that's not correct. That's patently incorrect. That was not the evidence of J.T. Williams in this court.
All right.
Might have been in another court, but it wasn't in.
All right, Ms. Levinsky, I understand you've made your objection, and I'll instruct the jury that you, again, are the sole arbiters of what facts were or were not presented to you in this case.
I'm gonna go ahead and finish the rest of my closing. But if I'm interrupted again, I'll take time to stop and disprove her. The items that I was just mentioning. Evidence. Two different types of evidence that we're going to ask you to consider. Direct and circumstantial. Evidence may be direct, circumstantial, or both. Now, you may use your reason and common sense to make your deductions and reach your own conclusion. Direct evidence is evidence that may be seen, heard, otherwise directly sensed. It may be brought to court in the form of exhibits or the testimony of direct witnesses to such matters. Circumstantial evidence is when direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion is not necessarily seen, heard, smelled, tasted, or touched. It's said to be circumstantial or indirect evidence. So part of the law that the judge will charge you is that you are to apply whatever weight you want or whatever weight you deem to be sufficient to either be some type of evidence, circumstantial or direct. But just to give you an example of some of the different types of direct evidence that were presented in this case, the direct evidence of the DNA test itself, the range of probabilities that, so when we say that the sundress, that there's over 500 billion on the verbal scale, that range of him contributing as a DNA factor on that sundress, that's direct evidence that he contributed. Presence of his DNA on the gear shift is direct evidence that he tested. That's for you to consider. The DNA, the evidence of his contribution on the French door, the evidence of his contribution on the scissors, those are all direct evidence that he was in the house. It's direct evidence that he touched those items. And because we know that Timothy and Yosha Bryant claimed the residence, they did see the shattered glass, they did see PCs, they did see rummage through drawers, they didn't see knocked over TVs and monitors. We know that that circumstantial is that it wasn't like that when we left. That's circumstantial evidence of that. So I'll give you an example. I woke up this morning and I woke up particularly early this morning, but I need it early. I can work on this. And when I got in my car, this is pretty much what I saw because I should have got gas when I went up to yesterday. But when I pulled up to the car, I got out, stuck my car in the machine. And when I put the pump in, I started to hear something sound like it was flowing from the tank to the car. Smelled something. It was a familiar smell because I smelled gas before. I had a long cut service when I was younger, and that smelled like gas. Well, as I'm watching the screen on the gas station, it's going up in gallons and dollars. And so when I get in and crank my car, I'm here. And so how did that happen? I didn't see any gas go into the car. I didn't see it drop. But I heard it. I smelled it. When I checked my account, it was less. When we talk about those inferences that you are able to draw from evidence, the inferences that you can draw from that direct evidence that the defendant was in the residence because his DNA was there, that is the defendant's phone because they called him and he answered, he acknowledged it. That's the same phone that the bill and that same phone number was in the U-Haul storage facility when he was apprehended. All circumstantial evidence of his direct involvement in this murder, his responsibility for taking the life of Kay Thomas. The first count in the state's indictment is a charge of murder. The judge will charge you, will instruct you that the state has accused the defendant, malice murder in count one. The elements of that offense are that the defendant with malice aforethought did cause the death of Kay Thomason by stabbing her with a sharp object. State is not required to prove what that object is because we can't say for certain. But we can say that based on the autopsy that was performed, the nature of the injury, the visual observation, we can make logical conclusions that it must have been some type of sharp object. It could have been a knife, it could have been a cuticle tool, it could have been the scissors, doesn't matter. Her carotid artery was severed by an intentional act of this defendant. And that is the direct cause of her death as testified to by Dr. Sullivan. But you also have your own common sense and can draw your own deductions and conclusions to those reasonable inferences. He was in the house right before she died. That's an inference. He took her vehicle. That's an inference you can draw. His phone was pinging around her residence. It's another inference. And if we're talking about this count itself and the charge of malice, those are derived either from express or implied, and they can be specifically implied based on the nature and circumstances of the crime. Well, in this case, one thing that was consistent in the officer that responded and the investigator Shane Barkley when he testified, and the testimony of Detective J.T. Williams. And that's that she went outside to that room to investigate what was happening. She suspected that something was going on. She even reached out to her daughter to say, hey, I think somebody's trying to break into my house. We know based on the video around that time, that was very well likely when this defendant was walking around 1095 Woodbine, June 18, 2018. Well, what can you use from what happened on June 18, 2005 to imply that there must have been malice and intent to kill in the mind of this defendant? Well, the stab wound in the back of her head, the bruising, you'll be able to see when you look at the autopsy photos. The bruising, that's an indication that she was struck, possibly repeatedly. Every time you see the bruises when you're looking at those, while you're deliberating, evidence of malice. Zip ties. When you're looking at those autopsy photos, you're going to see lines on her hands, her wrists, cuts, consistent. We know when she was restrained, logical conclusions about where those marks on her arms come from. When we talk about malice, I'm asking you to consider all those facts. All of those facts. We're sitting up here trying to figure out what was in his head. Certainly, no consideration for the life of Ken Thomas. Didn't care. I don't know what he went over there for. I mean, he took a car, dumped all the contents of the purse on the bed. And mind you, now, we believe based on the evidence, the first thing that happens is she's scared out of her mind and defecates. So after that, she's beaten. After that, she's tied together. I'm talking about inferences you can draw from the facts. And then after that, I'd have to assume she was beaten, stabbed, and put into the tub. After all of that, dumped face down in a tub of water. I say dumped, maybe she was placed, doesn't matter. But you want to know what shouldn't have happened? Shouldn't happen to anybody. But I mean, just thinking about that day and all the things that happened, it's impossible to infer anything in this defendant's mind other than an intent to kill Ken Thomas. Take her car, leave, jump it, what does she have in money? Going about his business. Precedent 22, whatever. Malice. State does not have to prove premeditation to prove, regardless of how briefly the malice intent existed, no specific length of time is required for malice to arise in a form in an instant. The state does not have to prove motive to prove murder. Of course, you can infer what the motive was because there's a burden, forced entry, there's things taken. You can infer that, maybe he broke into the house to steal something. Doesn't matter. The motive doesn't matter. Evidence of motive admitted for your use in determining the defendant's state of mind at the time of the killing. Any evidence. So in the state of Georgia, there are two different types of murder, well, several, but for purposes of this case, the state of Georgia also holds people accountable when they commit dangerous acts. And the commission of those dangerous acts or felonies, it calls the death of someone. So an assault in the state of Georgia is you make an action and that action puts someone in fear of receiving a type of injury. You swing at somebody, hit them. An assault becomes an aggravated assault when the object used to commit that fear to cause serious injury. And so that's why I say when sharp object, knife, scissor, cuticle, pole, bat, any object that can cause a serious injury, when it's used in an offensive manner, that enhances that from an assault to an aggravated assault, and that's the distinction. So in the state of Georgia, counts 2 and 5, you'll see count 2, the count of felony murder. And that's the felony murder charge, but it's predicated on count 5, the offense of aggravated assault, and the judge will tell you I can consider those 2 separate counts separate. The offense of aggravated assault, if you commit an act that hurt, fear, or receive a serious injury, you can infer that based on the circumstances of that night. And was that assault committed with a serious injury? That's evidenced by the cause of death. We believe she was stabbed by a sharp object. That also relates to counts 3 and 6. You'll see that on the indictment, false imprisonment. So when we talk about evidence of restraint, not allowing her to the residence, restraining her to the chair, in the state of Georgia, that is illegal. And that is a felony. And because that was being committed at the time she died, that's why we have the felony murder, because it's predicated on his restraint and that being the cause of her death. That totality of that night. There's another felony murder, three felony murders on the state's case, in addition to the intent to kill for the first count. Because you can commit an act over the series of a day or an hour or a period of time, and because that act can implicate a number of different things, a number of different crimes, there could be multiple charges for one act or one occurrence on one indictment. Give another example. DUI. Drive drunk, get caught. You may be charged with DUI. You drive drunk, get caught. Kill somebody while you're driving. You might be charged with it, DUI, and then you get a homicide. Same principle applies in this case. That's why we have 3 separate counts of felony murder, because he committed burglary. He restrained her to false imprisonment, and he stabbed himself. Now, judge is also going to charge you that testimony of a single witness, if believed, is sufficient to establish a fact. There's no legal corroboration of the witness, provided that you find the evidence to be sufficient. Excuse the fact. So that means that if you believe Ms. Grievous in her testimony, you're authorized to believe that just because she said that and you found her to be credible. That goes with every witness that testified. And each of you are the determinant of their independent credibility. So what do we have? So Ms. Grievous is planning to take her kids to a gymnastic event. And as she testified, they like to spend time with the mother and the grandkids. And this is supposed to be kind of a weekend, just like they do occasionally. And on this night, she already was concerned because her mother had reached out to her to let her know that there was something suspicious going on outside her residence, and that someone was attempting to break in. And she testified that she went upstairs, and her children were downstairs, and she and her friend went upstairs, and just immediately noticed that something appeared to be wrong. There was broken glass, there were chairs that were knocked over, things looked to be rummaged through, and then she found them out. And that's how we start this case out, because that's the 911 call that you heard earlier in this case. We get to the first responder who secured the scene, Officer Hashmi, and he was one of the first ones that told us about what he observed, blood and feces, chairs flipped over. To him, it was obvious. The first thing he saw was that it appeared as though someone had broken into the residence, was forced entry, and he called the homicide detective, and that was the beginning of this investigation. The importance of Timothy and Miosha Bryant It specifically relates to the DNA. But it is very significant that they cleaned the residence before because that assisted with the collection of evidence. That eliminated some of the possibility that you would have contamination and possibly mixtures of DNA samples. But this was important because this starts our process out in terms of who was in the house before, where should we swab, and beginning our beginning part of our scientific investigation into this case. We have investigator Shane Barkley, really a specialized investigator in crime scene investigations. And one of the important roles that he had was he had particularly specialized knowledge in collection of DNA evidence. He was really directing the rest of the investigators on that swab method with the wet swab and the dry swab to attempt to collect evidence everywhere in the residence that they possibly could. And we know that they collected over 100 samples that were sent to Georgia Bureau of Investigations as well as DNA Labs International. Detective Shane Barkley was also able to give you some insight into what happened that night. Because we do have the benefit of that experience, we know having the items from the residence, we're able to tell you where we believe she was positioned, we're able to tell you where we believe the struggle occurred, and of course the evidence of blood is some indication of where the attack occurred and where she was fighting for her life essentially. So we talk about evidence that rummaging or breaking in. These are monitors, and this is what Officer Hashmi would have seen when you walked into that residence. This is what Catherine would have seen when she walked into that residence. Then we, Officer Garrett, he's in real estate now. But at the time he was patrol officer, 2018. And at this point in the case, Detective J.T. Williams had located or at least 7 different devices. And they were able to pinpoint the device where so that one of the 7 devices was walking around the residence of Ms. Thomason. And so that part of the investigation gets us this phone number 404-838-3782. And that's the number that Garrett calls. And when he calls him, someone picks up, yes, this is James. And my email address is jamesjones04@gmail.com. And just so happens, when they actually searched the U-Haul facility, they found a black bag that really resembles the martyr video footage on a laptop that is the same brand as the laptop that was taken from the residence of Ms. Thomas the night she was murdered. Just so happens, and we can ask questions about them. I'm not gonna argue with you about whether or not that's a laptop. We can draw evidences, but here's the thing. Laptop, same brand as Ms. Thomas. And it just so happened to be wiped clean a month after it was taken from a house. So, I mean, that's an inference. I'm gonna move on. But you also find that phone. That's the phone Garrett called. That's the phone this defendant answered. That's the phone that was at 1095 Woodbine, June 18, 2018. That's the phone he had in 2020 in his facility when he was arrested and apprehended. Those are the zip ties that he had in his possession at the time he was arrested in 2020. That's the phone bill he had in the U-Haul facility at the time he was arrested with the same phone number and the same email address. He did it. He did it. And now, I don't know why she showed this. I think this is further corroboration. He over there dressed like a woman. Look at him. Look at breast and hair and trying to be a woman, and this is estrogen. Hormone pills. Female hormone. Is that not corroborative? Why would she show that? I don't know why she did, but that's corroboration. That's corroboration. And he can do whatever he wants. I don't care about that. I want him to be held accountable. He can dress like a woman all he wants. I don't care. He killed Kay Thomas. I don't know why we're talking about what he dresses as. That grown man tied up in that chair. That man, that's a man. Killed her. Hit her. Scared the shit out of her that night. Defecated on herself. Jenna Bryant, geofence expert. So we know the Google records came back in 3 phases over a 6-month period. This was a significant part of the case. I don't know what's more important, DNA or geofence. That's for you to decide. I think, well, I'm not gonna say what I think. But we talked about the certified records that were received from Google. This was within that series of 3 records that were received over 6 months. This kind of gets us the identification. Whose phone is this? James Jones 4@gmail. Got the phone number, we got the email address. So they know who they're looking for now. Gotta figure out who James Jones is. Then go and talk to his uncle, get closer, trace his phone number, tracking it in real time to that U-Haul facility, and there you go. So part of the testimony of Investigator Bryant, the red dot is 1085 Woodbine Road. And you see here, the yellow boxes that she testified, these are the areas where she observed on surveillance video, suspect walking. I say suspect, I mean the person, whoever had James Jones's phone that night. Now let's just clear it, right? That person was walking where the yellow boxes indicated. And so then we do an analysis of all the other devices and nothing significant until we get to phone device 7. And so now we're saying, okay, this is why we go and specifically ask for James Jones's phone records, because that's the phone that's at 1095 Woodbine. And you get the additional records and the Google records in the series of 3 over that 6-month period, and they get even more insight. Over this 6-month period, they get closer and closer and closer. I got the impression that J.T. Williams was kind of feeling that he was getting closer because of that testimony of him. Kind of feels like he kind of thought maybe something was about to break in the case. Because now we got him traveling 11:27 p.m., 11:20, Chamblee MARTA station. You saw him, you saw the route. You watched the presentation, the videos of him entering and exiting these MARTA stations on the videos from Chamblee Station at MARTA, 11:20, all the way down to the residence, 1095 Woodbine. Detective Analyst Bryant tracked him. That phone number that's in U-Haul. That phone he had in his possession. That's what's depicted on the board. This is his travel the night Tim Thomason was murdered. You see, from Marta, this is where he ends up at. And we know what time this kid come out of the house was, it starts at 1 day. What was that time frame from the surveillance video? 1 to 3:13. So we tracked him from Marta and Chamblee, and now he's at 1095 Woodbine at 1 o'clock. And I'll be doggone it, that's the same thing you saw in the video. 1095 Old Woodbine Road. There he is. What does the science say? The first step in this process was to submit evidence that was collected at the residence of A. Thomason to the GBI. And it wasn't the things that the GBI were going to be able to do, the tests that they were going to be able to perform wasn't sufficient. It wasn't sufficient for the detective in this case. He wanted to do more. And that's not to say anything negative about GBI or anything positive about Sandy Springs or in particular J.G. Williams. A difference of opinion is a difference of opinion. Experts have opinions. You've heard these experts that were qualified unchallenged come to court and they told you about the work that they did. They told you tested fingerprints. They told you other individuals of interest. Things that they were really doing was assisting with the process of either determining suspects or limiting potential suspects. And that's the part that they played in this. And you have Christina Servideo, the expert in forensic DNA and serology that we came from Florida, DNA Labs International. And she talked to you about the process of testing DNA. Everyone has a male and female contributor for their mother and father. And there is a quantitative way that they attempt to measure that they internally verified whether something is informative or not, and the degree to which it is. And so that's what's been outlined in the different things that were tested out of all the over 100 items. So you have the sundress, the armrest, the French door, the light switch, and the scissors. You have items that were in Kate Thomason's residence, and you have items that were in Kate Thomason's vehicle. You have different degrees to which this defendant has contributed his DNA to each of those items. And the sundress is probably the most significant because that's what she had on when she died, that's what she had on when she was murdered, and that's what she had on when she was found. So in all likelihood, that is going to be the location where you're going to find the most DNA, because based on the injuries that she had, it is very likely for you to infer that he either had her in some type of hold, that she was fighting back, attempting to get him off of her. But the injuries and the way the house looks, it is very much in your ability to infer that that is very well going to be where the most DNA is going to be, because that's what the struggle was on her person. It's over 500 billion on the verbal scale. The scissors are over 840. Light switch in spare room, 4,200 more probable. French door, 19 million. Armrest of console, vehicle 43 times more probable. Dealership 29. Dr. Karen Sullivan just brought the court to tell you cause of death, because that's an element that we have to prove. And obviously, cause of death was more likely proven before she testified, but in an attempt to be as thorough as we possibly can, she came and told you exactly what the damage was based on her view of the autopsy, the photographs. Expert opinion is the chief medical examiner for Fulton County Medical. She told you that the loss of blood that she experienced because of the damage to her carotid artery is the cause of death, and you're authorized to find that expert opinion valid. You're authorized to find that credible. You're authorized to find that expert opinion is true and the cause of her death. Investigator J.T. Williams. Now, when he gets that call while he's having dinner with his family, he makes his way to that residence, and at that point, no leads, no nothing. Over 100 tips investigated. Over a year's worth of investigation. All he knew at this time was that Kate Thomason didn't deserve what happened to her on that night. And he knew that based on what happened, it was a brutal attack. They knew immediately when they left that she was extremely frightened. They knew that her place had been rummaged. They knew that she had been beaten, that she had been tied up, and essentially tortured. So yes, when they left that scene, they were extremely motivated to do whatever they could to solve this case, no matter how long it took. And while they investigated tips and canvassed the area, they requested the Google records. After they received the information about that training, they requested the record, they prepared the search warrant, and they worked the Google evidence as it came in over that 6-month period. They located the 7 devices. They focused in on that phone number we now know is the phone of this defendant, James Jones, and proceeded from there. That phone. That phone. Once he got that information of the phone number, provided that email address, jamesjones04@gmail. He continued on with the DNA evidence. Because at that point, when the defendant's arrested, he gets an opportunity to swap his cheek. Sends that evidence to DNA laboratory, and they begin their testing. Not only do they test James Jones, you have to remember, when we talk about $100,000 being spent for a job that we are trying to be thorough in, part of that $100,000 was used to eliminate 3 potential suspects. We sat up here for I don't know how many, 40 minutes, an hour, going over all the different things that she tested. And it's her video. You know, I worried I was putting you guys to sleep, but it was necessary to go through all those items because I wanted to show how thorough we were. But every trial I have, the defense attorneys always say, well, they could have did this, they could have did that. So that's the balance. Overwhelm you with information or something like not giving you everything. But the point of that was to show you how thorough we were being. So we talk about spending $100,000 on testing to hold someone accountable for one of the most brutal things that Sandy Springs has seen. I would say that part of that money was used to eliminate potential suspects. I would just like you to consider that as well. So when we talk about malice, when we talk about what should and should not have happened that night, when we talk about evidence of injuries, That's what we're talking about. So when JT Williams is talking about evidence of injury, what did you see that made you believe that she was attacked? That's exactly what we're talking about. Things that should not have happened on June 18, 2018. This is what we're talking about. Things that should not have happened on June 18, 2019, 18. And the most important thing I want to leave you with before I sit down is that the most important thing of the week is that this process be fair, fair to this defendant, fair to the victims, fair to this community. And, ultimately, we can work on these things. Sandy Springs can investigate, but we have to have our community decide these issues. And so ultimately, the defense and the state are depending on you to vote the truth. I'm asking you to hold this defendant responsible. I'm asking you to hold this defendant responsible for the murder of King Thomason, June 18, 2018. This is something that should not have happened. Unjustifiable homicide.
Yes, may I proceed when ready?
Your Honor, I think we need to discuss whether we should proceed at this stage, bearing in mind the time.
We'll do this, Ms. Levinsky. We'll go at least an hour, and then we'll check in on where we are with that.
We don't want to be in the middle of an argument.
May not want to, but we may have to. Members of the jury, let me actually just do this by show of hands. Is there anyone who would have a scheduling conflict if we stayed past 5:20 today? All right. Seeing none, then I think, Ms. Levinsky, we can proceed.
And can we finish the state's argument then as well?
No. We'll conclude that first thing in the morning.
Your Honor, that
That's just how it lands, Ms. Levinsky. I understand you may not find that ideal, but I think that's how we have to proceed.
It's far from ideal, Your Honor.
Understood.
Thank you, Your Honor. I'm trying to set up my. Can you help me see?
Stop myself from saying something.
Yeah. Well, yeah, I did. I did. You did good. Yeah. You bet you. I'll preach if you okay. Just whatever you want to do. Write stuff down.
Good afternoon. On Tuesday morning, I told you that James Jones did not murder Kate Thomas. I think that having heard the testimony, you now know that that is correct. But before we go there are certain legal principles that I'm going to want to discuss with you. legal principles that protect one of us, should we find ourselves in the position of Miss Jones, an innocent woman charged with a crime she did not commit. And despite Mr. Fawcett's ranting about Miss Jones being a man, she is, to the knowledge of everybody involved, a transgender female. She goes by the name of Priscilla. So I will use, and I will always continue to use, the pronoun she. I believe that the state, throughout this case, have continued to use the pronoun he deliberately and disrespectfully. But now let's talk about the legal principles that govern every one of us. Firstly, the presumption of innocence. Miss Jones is presumed to be innocent. That presumption of innocence remains with us, with her, until it is disproved by the state with evidence which is sufficient to convince you beyond reasonable doubt that she is guilty of the crimes charged. The burden of proof. This is important. The burden of proof rests fairly and squarely on it. It never shifts to the defense. So if you have any questions, if, for example, you want to know why Detective Johnson or Detective Delaney or any of the CSI officers were never called to testify, for example, you don't look to us for the answer. You look to that table over there for the answer. You remember when Detective Barkley was sitting up there and he was saying, gee whiz, I can't remember what I collected. I need my evidence records to show what I collected. You don't look to us to produce those evidence records, which would have refreshed whatever recollection that Mr. Barkley actually, no longer Officer Barkley. You don't look to us for those records. You look to the state for whatever questions you may have. And any doubts that you may go to the benefit of Ms. Jones. Burden rests on the state. No burden rests on the defendant. The burden of proof never shifts. She is not required to prove that she is innocent. I think you can understand this. Imagine, somebody comes to you 2 years after.
You're not asked that the defense not ask the jury to put themselves in the shoes of anyone. I'd object to the way the question of the statement is being phrased.
Let me rephrase.
All right.
If somebody came to me and said, where were you on a particular day years ago? I know I wouldn't have a clue. The state must prove that she is guilty. The state must prove each and every material allegation of and each and every essential element of the crime charge. No person shall be convicted unless and until each element of the crime is proven beyond a reasonable doubt. So let's talk about what's beyond a reasonable doubt. What does that actually mean? It is the doubt of a fair-minded, impartial juror. That's all of you guys. Fair-minded, impartial jurors honestly seeking the truth. It is a doubt based upon common sense and reason. It is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, a conflict in the evidence, or any combination of these. And when you look at doubts, and you go back there in the jury room, and you consider whether you have doubts and what those doubts are. Your doubts do not each have to be the same. So you, for example, may have a doubt because you are concerned about the testimony of a medical examiner who did not even perform an autopsy. You, for example.
Yeah, and I'm gonna object to the way the statement is being made in terms of it directly addressing a juror and their personal reaction to a scenario.
I'll overrule that. You can proceed. It's overruled. You can proceed.
Thank you. You, for example, may have a doubt because you're concerned about the way the evidence in this case is collected. You, for example, may have a concern after hearing that the GBI refused to test the nightshirt because they said they weren't going to test a piece of evidence that had been soaking in water for 12 hours. So instead, Detective Williams decided to send it to some private lab and pay $114,000 to get a result he liked. Your doubts do not have to be the same. Any doubt, any reasonable doubt you may have goes to the benefit of the defendant. And I understand that having heard the 911 call, heard the testimony of Miss Thomason's daughter, having seen the family in this courtroom, our hearts go out to them. It's horrible. But the one thing we all know is that justice is not served when an innocent person is convicted. Justice is never served when an innocent person is convicted for several reasons. The obvious one is, of course, that it's not justice for Miss Jones. But the other one is, of course, that it is not justice for Miss Thomason's family. Despite what the state may say, it is not justice for Miss Thomason's family to convict an innocent person of a crime they did not commit, because the person who actually did it is out there somewhere, possibly committing other crimes. That's not justice. That doesn't help society. That doesn't help anyone at all. So this is a little chart I like to use to show you what it means when we talk about beyond reasonable doubt. So you've heard the evidence, and you've heard all the stuff about, well, you know, I filled my car this morning, and when I got back into my car, I saw that the petrol gauge, the gas tank, I come from another country, we use different phrases. I apologize. When I got back into my car this morning, the gas tank showed full. This is not a gas tank, but that's circumstantial evidence. And this dependent on circumstantial evidence. But having heard all that circumstantial evidence, you look at it and you just say, well, I don't think Miss Jones committed the offence. Problem solved. We can all go home. But perhaps you say, well, maybe she might have committed. There's all this stuff about geofencing and Google location and DNA, and it's possible that she committed the offence. That simply is not enough. Let's go a step further. You look at it and you say, well, with this DNA, and they say there's this 550 billion likelihood ratio. Oh, her guilt is highly likely. Even that's not enough. It's got to be guilty beyond reasonable doubt. Another principle of our judicial system, one of these principles that protect each of us and that are enshrined in our Constitution, is that the defendant in a criminal case does not have to testify or present any evidence. And if the defendant does not testify or present any evidence, you cannot hold that against her in any way in making her decision. And again, the reasons are fairly obvious. She has told you what her defense is when she entered her plea of not guilty, as she did. And we already discussed the difficulties of being faced with a situation more than 2 years later. And there are other reasons why people may not choose to testify one of which is the rent we were treated to a little while ago by Mr. Forsett. She's a man. She's a man. Why does she choose to sit over there in woman's clothing? No, she's not a man. She's a woman, and she can wear whatever she likes. And she can choose to be whatever she likes. And we cannot tell her who she is. And Mr. Forsett and the state cannot tell her who she is. The judge will give you instructions at the close of the case, and the things I've told you are the things he's going to tell you. But the other thing he's going is that to authorize a conviction on circumstantial evidence, which is, of course, what we have here. The proven facts must not only be consistent with the theory of guilt, but must exclude every other reasonable theory other than the guilt of.
He's not getting that instruction. That's not true.
Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charge, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction. This is our law. It's there for a reason. So I want to talk a little bit about the evidence, and I don't plan to go in detail through all of the testimony. You heard the 911 call, 911. It was heart-rending. It really was. And you watched the testimony of, I'm going to massacre her name, Miss Kreiglas. She is a lovely woman. I have the deepest sympathy for her and her parents. What happened to her mother is horrible. And I quite agree with the state on one thing. It's probably the one and only thing I will agree with. Kay Thomason did not visit the down. Muhammad Hashmi, he's the first responder. He described the scene. Miss Thomason dead in the bathroom at the top right of the stairs, and the signs of a struggle. And why are signs of a struggle important? What happens when people struggle? What happens when people fight with each other? And they get injured. You know that yourself. I'm sure any of you who have ever fallen, been involved in a struggle, you know, you get injuries, you get bruises, you get cuts. They happen. There's a broken mirror, glass, and of course the purse contents laid out on the bed. Fecal matter on the bed. And we've heard two things about it. We've heard Detective Williams say, oh, that's what happens when a person dies. And we've heard Mr. Fawcett say, that's because she was scared. And we've also heard from the cleaners that there was feces downstairs when they cleaned the house long before any of this happened. And the cleaners, Mr. and Mrs. Brand, said that, well, Mrs. Brand, sorry, Mr. Brand couldn't any feces, although Mrs. Brand said that she asked Mr. Brand to pick it up. But she said she believed there was actually feces upstairs as well. And that's long before any of this was happening. We don't know what happened. We really don't have a clue what happened in that house. He also talked about signs of forced entry at the back door. He's the only officer who talked about signs of forced entry at the back door. And again, of course, this is probably not correct, because according to Detective Williams, the doors were unlocked. In fact, Miss Thomason, for whatever reason, had, and perhaps it wasn't Miss Thomason, perhaps it was somebody else, perhaps it was the handyman, perhaps it was whoever else had entered her house under whatever circumstances, had taped painter's tape over the receivers on the door so that the doors could not lock. And somebody had taken doorknobs off the door and placed them in the drawers. So there is no forced entry. Again, we do not know what happened. Keith Sawtell, I think he's an important officer to talk about. I'm not going to talk about all the officers. But I do think Keith Sawtell was an important officer to talk about, because he is the person who processed the DVR. And the DVR is the thing that points the police in the direction of when this happened. So he looks at this and he processes it, and he tells you how he went about processing it. And he testifies that the time and date were off. And the date was off to January the 10th. And the time, he says, was off. And you will remember that I asked him to tell us, well, what was the correct time? please tell us what was the correct time? And he sat over there for a while, trying to do the math, to calculate the time difference, but he was actually unable to do so. So what it boils down to is we have absolutely no evidence which tells us what time the suspect shown on the video actually came into this property or in the vicinity of this property. We literally do not know. He's the only person who testified about processing the DVR and obtaining the times. Detective Williams did not do so. And he couldn't tell us what the time difference was. And then he talks, and I'm going to talk about this because it shows, I believe, the bias that all these officers, even ex-officers, have. He claimed that he found a laptop in the storage unit that was occupied by Miss Jones. That, quote, matched the laptop which was missing from Miss Thomason. First of all, he's the only officer who testified about a missing laptop. Not one other single officer testified about a missing laptop. Neither, incidentally, did Ms. Grimes testify about a laptop. What was missing was a card. So there was no suggestion of a missing HP laptop. But hey, he finds this laptop and he says, I found it and it matched the victim's laptop. Okay, what was the description of the victim's laptop? Was an HP laptop. That's a great description. Can you tell us anything more about it? No. That's a pretty generalized description. I would venture to guess that of all the people in the courtroom, probably at least half a dozen have HP laptops. They probably matched the description of the laptop found in the storage unit. I then asked him, well, did you process the laptop? Well, actually, it had been wiped clean. He also claimed to have seen zip ties on the scene that night. And he said, oh, I could see these zip ties I found in the storage unit. They matched the zip ties I saw on the scene that night. Really? zip ties were found on the scene. None. There is absolutely no testimony, not one iota of testimony, that zip ties were found on the scene. I specifically asked Detective Williams, and he said none were found on the scene that night. And they're acting like having zip ties makes you a criminal. I'd venture to suggest that probably most people in this courtroom have zip ties in their home for a variety of reasons that do not include restraining elderly ladies. This is what happens with these investigations. Wanted to talk about Detective Bach. He is the detective who was in charge of the crime scene investigation. That's the detective during which they set up that little display with the chair, the carpet, and the door. And he said he couldn't remember what, if anything, he collected other than possibly the carpet and the chair. And he kept on saying, and he said it repeatedly, well, you know, I would need to look at documentation to see what I actually collected. Because he didn't do a detailed report. Remember that line of cross-examination? You're the head of the crime scene unit, you're trained in writing reports. You didn't do a report that detailed what was collected. No, he didn't. And he was looking for documentation, desperately looking for documentation. He said it repeatedly. And nobody at the state's table can produce any documentation to enable him to tell you what, if anything, he, the head of the crime scene investigation unit at Sandy Springs, collected. He also cannot remember who was processing the crime scene. The detectives who were processing the crime scene. Oddly enough, Detective, I think it was Sutton, was able to tell us. He could remember Detective Johnson and the Detective Delaney, neither of whom testified. But Detective Barkley couldn't tell us who the detectives were that were processing the crime scene and collecting the evidence on which they rely for their DNA evidence. Because DNA doesn't come from nowhere. It comes from the evidence they collected. And there has to be a chain of custody to show you how that evidence was collected, who collected it, how it was stored, etc., etc. And they can't even tell you who collected it. He dusted the scene for prints. This was a bit confusing. He started off by saying, well, we weren't going to dust for prints because we don't want to get intrinsic. He liked words like intrinsic and artifacts. We don't want to dust for fingerprints because that gets intrinsic and it may disturb the evidence. But he then says, well, after we did the DNA, we did, in fact, he believes, dust for fingerprints. Did you hear any evidence in this courtroom about the results of fingerprint processing, fingerprint examination? I didn't. But sorry, before I get to Jane Bryant, I wanted to talk about Sean Sutton. Sean Sutton is the officer who was helping with the crime scene investigators. And maybe I've got my order wrong. Maybe he came after Jane Bryant. But he is the person who mentioned Johnson and Delaney. And he's the person who told you very clearly, I'm not a crime scene investigator. I'm not a crime scene investigator. And I was helping them, but all I was doing was putting tubes in boxes. Johnson, Delaney, they don't testify. He also told you something else. He is the person who told you that he got the martyr video footage and did not keep a report of any nature about it, or forgot to preserve the report. And he claimed that he had obtained that report, I believe it was on June 30th, and he had obtained that video footage, and he found a suspect, and he'd shown it to J.T. Williams. Hear anything about that suspect or Sutton obtaining that video footage from J.T. Williams? I didn't. Let's talk about Jane Bryant. Now, she is the person who used the mapping software to analyze the location data received from Google. And this is realistic, the basis of the warrant for the arrest of Ms. Jones. Prior to that time, Ms. Jones had not been mentioned by anyone to anyone. She was nowhere in the picture at all. Along comes this new technology. This is the first time it is used. It's brand spanking new. So she looks at it and she does her bit. And she says she has no idea how Google obtains their location data. When I asked her that question, she said, ask Google. Did you see Google testifying here? Must have been on a day I was out. They did not testify in this court. First heard of geofencing warrant about 3 weeks before they obtained the warrant in this case. Notice that Google stores the information in something called a sensible. But she doesn't know on what server Google maintains that file. She doesn't know who maintains that fault, who works on that fault, who has access to that fault. She says she watched the video footage approximately 20 times. She knew that the time on the video was incorrect, but did not know what the correct time was or who ascertained the correct time. Back to our little problem. Gee whiz, we're analyzing location data for a particular time, but we know what time the incident occurred. We really don't. We have video footage, and we know the time on the video footage is wrong, but we do not know what the correct time for the video footage is. And we don't even know, as we sit here today, who ascertained the correct time, or if anyone ever ascertained the correct time. And they want you to convict a person of murder on the strength of this evidence. Quite seriously. We're having a little experiment called geofencing location data. We've never used it before. We don't know anything about it. We don't call Google to explain it. We don't know the correct time of the incident, although we have video footage. But just convict that person over there of murder because, well, she claims to be a woman. How dare she? So she does her mapping software. And what she tells you about her mapping software is that her mapping software showed that the device with that particular ID, 125882129, was not in the house at 1095 Old Woodbine. Doesn't matter. Convict her anyway. Who cares? The location data from Google showed no location data from that device from 3:14 a.m. to 3:57 a.m., indicating that it was powered on. Why is that important? Remember J.T. Williams' testimony about person coming out with a cell phone? Oh, incidentally, Jana Brandt watched that video 20 times, just never even saw it. What was she focused on? She was focused on where. And what did she tell you about the location data, history she obtained, and the mapping information obtained? Her decision was based on her belief that the device was moving around in the distance. Other devices were stationary. This device was moving around. Apparently, moving around in that area makes you guilty of murder. I must remember never, ever to do that. She also told you that location data is not accurate. And then she said that this was the first time she had used Google location data. Miss Jones' arrest was the result of her experiment. What she then does is gets phase 2 and tracks this device walking from the Chambly martyr to that area. Now, I have in my time in Atlanta been known to use martyr. I did not know it was a criminal offence. Had I known it was a criminal offence, I definitely would not have done so. I have been known to walk in that area. Had I known that was a criminal offence, I definitely would not have done so. But that is the basis for the warrant for the arrest of Miss Jones. Oh, sorry, I'm wrong. I forgot the best part. Phase 2, she gets information showing that the device switches on at 5:37 a.m. near the martyr station. And she prepares in her demonstrative exhibit a document which shows a time at 5:35 a.m. at the Azalea Park Apartments. And she actually admitted that there was no data location information for 5:35 a.m. That was simply, I guess, sucked out of her thumb to make the demonstrative look better. That's what we deal with. They're trying to convict this person of murder. Let's talk about the DNA experiment. And she told you how she prepared 6 reports. She couldn't give us a clue on as to how much she was paid. Well, we know now how much her laboratory was paid, somewhere in the region of $114,000. That's an awful lot of money. She also didn't have a clue how much they were being paid for her testimony yesterday. Again, I question that. But they were a private lab in Deerfield Beach, Florida. And they were used because the GBI had the temerity to tell Detective Williams that they could not obtain accurate details from a nightshade that had been soaked in water for 12 hours. How dare GBI experts tell that to Detective Williams? He clearly knows it. So she tells you that as far as it relates to Miss Jones, there's strong support for the presence of her DNA on 6 items. And we talked about those items. And for each of those items, we pretty much had the same scenario within limits. She had previously run each of those items against DNA samples using only 2 contributors, inputting only 2 contributors into the software. She then received the DNA samples for Miss Jones, and she ran her DNA in the same way as she had the others, using only 2 contributors, inputting only 2 contributors. And guess what happened? She got an exclusion. Miss Jones was not the contributor of that DNA. Now, this was not a satisfactory result. For whatever reason, this was not a satisfactory result. So now, for the first time, she decides to run it as 3 contributors. And she told you, she admitted it. When you add extra contributors, there's a higher likelihood of a false positive. She had not run 3 contributors on any of the other suspects. Now they're getting desperate. See, this is all about desperation. Everybody's getting desperate. They want a resolution. They've made an arrest. They need to get this person convicted. They've arrested this person and they need to get her convicted. So now they're getting desperate. So now they run it as 3 contributors. And they come up with these enormous statistics. And even with these bizarre statistics of millions and billions, she cannot say that James Jones' DNA is actually part of the profile. The best she can say is that there is a strong likelihood all roads to that. And she uses a terminology that is terminology that they have themselves decided upon. And she is then asked about the fact that there was an issue with her laboratory. They were found to have used improper methods. And she says, well, yes, well, but they didn't affect this. Because, hey, it didn't affect these items because our internal validation says our methods are fine. I kind of wonder who you trust more, the GBI, and remember the state put up, I believe it was 3 witnesses from the GBI, some of whom talked about DNA, or Miss Servilio and her $114,000 payments. And judging from her testimony, it looked as if she was retained largely by police stations. And then, of course, there are dozens, literally dozens of items from which James Jones is excluded as the contributor. Or if not excluded, the result was inconclusive. And then again, as I said, well, this is the situation in which the GBI said, we're not doing this because nothing you get from us is going to be accurate because it's soaked in water for 12 hours. But if we're being paid for it, we'll do it. Dr. Simon. She's the medical examiner, and she did not do an autopsy. She made a determination regarding the course of death from looking at between 5 to 7 photographs of the outside of the body. She did no internal examination, saw an injury to the back of her neck, and assumed that that was what killed her. At no time did she testify that she was beaten. Now, I think we all that when it comes to cause of death, you don't just make that determination by looking at a picture and seeing a hole at the back of the neck and saying, yeah, well, there's a stab wound at the back of the neck, therefore that's the cause of death. If it was that easy, we'd skip the whole autopsy process and just have our medical examiners come down to the crime scene, have a look at the body and say, oh yeah, I see a hole there. That must be the cause of death. We know that there are things so far beyond that can cause death. So many other potential causes of death, particularly in elderly. And Miss Thomason was an elderly person. Incidentally, talking about elderly people, I'm not. I know from myself. You know, when you're old, your skin is thin and you bruise easily. You develop marks on your skin with the greatest of yours. I'm skipping things. Each like that, actually. I get it. J.T. Williams. Remember his testimony, no zip ties were found on the scene. He talked about all the suspects he considered. I wanted to talk about one of the suspects, the person who had easy access to the house, who lied to the police, apparently more than once, who had a motive to be angry with Miss Thomason because she was threatening to pull his bond and making him work out. They kind of brushed that off as if it was nothing. They didn't run 3 suspects on Sean Holt. They ran 3 suspects on James Jones. Why? What's the difference? He told you about spending $140,000 on private DNA instead of using the GBI. I'd venture to suggest that that is extremely unusual. And then he talked about how he had walked around and followed up on this case. And one of the things he told was that he actually ate lunch in the vacant house in which this crime had been committed. Perhaps it's good policing, but to me, it smacks of desperation and obsession. And that, I believe, is what the situation was with Sandy Springs when they did the GBs and obtained the warrant for English students. Another question I'm asking about whether he noticed that there was no data after 3:14 a.m. And he said, well, not that, but he knows the plate. He's still not playing the one. He knew she couldn't. You know. Sometimes what we mistake for good police work is perhaps obsession rather than doing proper detailed investigation. And when we look at the way the evidence in this case has been presented, I would venture to suggest that there has been no harm to influence the manner in which the evidence which the state relies for the none of what's said. We literally do not know who collected the nutdress that the state relies on for their DNA evidence. We have no idea who collected it. We have no idea how it was handled. Normally, you would hear evidence from the person with the autopsy, and they would tell you that it was packaged, etc. We didn't have that. He relies on the geofence warrant as the sole basis for his arrest. I'm asking you to think very hard about the evidence, to consider all of the loopholes, and I think there are one or two like that, if I may have one moment. I want you to think very hard about it. I want you to realize that there are consequences to whatever happens here, whatever the decision. And I want you to remember I also want to thank you for your time, your patience, your consideration. I apologize profusely if I have offended you in any way, if I have bored you to distraction. I think I might have bored some of you this afternoon or irritated you beyond. We all realize how important this is. What I am asking you to do is to do what you did when you took your oath at the beginning of this trial. To hold the state their burden to prove the guilt of Miss Jones. Procedural beyond reasonable doubt. Please find him, send him. Thank you for your time. This is the last opportunity I get to talk to you. Don't breathe a sigh of relief. Not only yet, the state get to talk to you some more. And I don't get to respond to that. So if they say something, I would ask to be neutral. when he says, think about how would Miss Levinsky respond to it? Please think about it. Think about it when they say so. Thank you.
All right, members of the jury, if anyone needs to step out briefly, I'd still like to use this time we have together to have the state begin. And then you can tell me around when we get closer to 5, if that's an estimate of how much time you have remaining.
I would estimate between, I'm just throwing out a number here, maybe 20, 30 minutes at max in terms of any remaining time. Of course, ask for remaining time on potential closing.
Hmm.
Yeah, 20, 30 minutes maybe.
Then it sounds like we'd be ready to conclude today.
I think the preference would be, since we were anticipating with the initial statement that it would be tomorrow, but if the courts would like to do it today, then we could do that as well.
All right. Why don't we can take a quick 5 just to let everyone stretch their legs, and let's try to have it so we can start fresh with opening or the instructions when we come back tomorrow morning. So let us know when you're ready, members of the jury. We're just going to take a few minutes here.
I mean, well,
We already got a. Say something.
what do you want me to do? What do you want to do? You want me to do it or you want to do it?
If you don't mind, if you're worn out, I'll do it. I think we both worn out, so.
What's that?
I'll do it.
All right. I'll wait for that light.
So,
Let's resume no later than 4:40.
I think the important thing was she said he wasn't excluded from it yet, that he ended up being included.
I mean,
But I think you need to say,
the
look,
first time.
you need to say, look, he. As interesting as it is, and how as much as we want to, want you and the jury to listen to what we have to say.
Oh, I think we must have said what you just heard over the past hour and a half.
I know, and then you want to, I do in a lot of ways, but in a lot of ways, I'm like, well, but I do want you to listen to what,
Sure, yeah.
you know? But I would point out. Yeah.
Write down some ideas.
DNA, phones,
Yeah. Roads.
it's like a kaleidoscope. It's like the glass, polarized glass. Polarized glass. If you look at a certain way, it's all black. It's all fog. I want to tilt your head. So crystal clear. And that's when you have the one. Everything. There's no doubt about it.
Yeah.
It sounds like you can.
All right, I'll do it.
You got it.
I'll do
You
it.
got it.
I'll do it. Yeah,
I'll be honest with you. I think
all right,
this
all right, I'll do
is
it.
natural.
I'll do it.
Don't you think?
But I don't have any slides.
You know,
I ain't doing any
I
slides.
never do slides for the second.
All right.
I most of the time, I might be 5, 10 minutes, but I don't have, I have it. That's fine.
I'll do it. I'm better watching it.
Hey guys, what's going on? I'm not finished, or something.
I'll do it.
You haven't finished. No. Finish.
So now we're down.
Well, there's still 21 wins.
Well, sorry, you did 2 witnesses today?
No, we had 23 yes.
No, they said that, they said they want 23 more witnesses. And then so today, I feel like we only have.
Yeah, they got rid of 2 more, so I got to 21, but then we cleared today, we had 2, 3 this afternoon.
Oh, yeah.
And then we had.
I just, there was.
Well, there's times I remember him, I don't want to just.
How does the jury?
Very well was upset and we can.
Yeah.
I haven't really looked at it.
Yeah.
Judy's behind her. She's like, "You're upset." She's like, isn't it? We have.
No,
We have.
not all of
ants, we have
Like 6.
Is one ankle and a person.
That passion has.
She does, but yeah, she.
Oh, she did.
And that.
Oh, she's a man.
Don't know why they have the custom and that stuff, but.
Does it keep going up? Well, it is the summer. You only got 1 case on it, right? You could get Hornsby Culpepper to do the revocations for a change.
Yes, he is.
Okay, good. That's how it ought to be.
That
That could be a good announcement.
No, they're brothers and sisters. It's not an hour, they said that.
Remember, I have one for you.
Have what? Uh-oh, here it comes. What you got?
You can come and bring me the review, Scott and I go come going for you.
Huh,
That's a good one. Right?
okay, sure.
I'm serious. That would be interesting if that happened. You know that?
A lot of work, right?
You take it?
Actually, I think we're talking about governor may be interested in that job. You need a bit better resume. No, you need a better resume to get that job.
You read that resume. Scott, I just made a deal with the judge. I said, when he become the president, UGA, me, you gonna go down there and work.
It's a fun town. Athens is a good town. How they doing back there? They ready? Yeah, I knew they did. They've been soldiers.
Judge, just to let you know, I'm gonna conclude.
Okay, great. Do you have a PowerPoint as well? Okay.
He's just started rolling. Lay out the page, man. Can do that. I said, that's all, man. That man be laying me out. I drink once a month.
They're not giving him take still. But there's no allegation. So he looked at me. Yeah. Kind of was like, nah, maybe watch this tape. Or and it's a lot of things, but goes up, Sarah feels running back, jumps up, and caught it. For the third out. That would say ended up. See something else going on too?
Were you stationed?
I was stationed in Korea.
I know that.
No, I was stationed in Korea, Germany, Turkey.
Oh, wow.
Yes, Turkey was stationed. And that's hard to jump on because.
Not good. No. Okay.
Yeah, the concept on there.
Just hanging out.
Help my main thing.
What's that? I'm just gonna put a picture.
Just keep checking on it.
Want to bring to the military?
Oh, yeah, okay.
Yes, they did say. For the 8 or 9 slot because.
Not getting up here at 5 a.m. tomorrow. I'm riding Martian.
Okay. Well, I'll tell you what. If it ends up here, hey, take it to the train station if you ride Martin. Cause I'll be.
Oh,
Yeah,
man,
so
that's fine. Yeah.
Oh, yeah. Yeah.
I appreciate
I'll
you.
make you listen to rap music on the radio.
That's all right. I don't mind it. We gotta turn the VR on. YouTube.
I didn't want to hear this.
I understand.
Is it a?
It's actually there.
Yeah.
But it's.
What would like send it?
It's pretty, this is speeding size. Yes.
I've got his, the last. This is the best thing she's ever
Oh, the officer training camp. Yes.
You mean the open, where it's open?
Training camp. Oh, they got.
Yeah.
Tickets.
And they still on the 6th. No plane at 6:79. And they can manage it. It's like, oh, over the way.
Good to know.
Oh.
Starting Friday.
Oh, that's right. That's why I guess that's what she does, right?
Oh, yeah. I'll do Sunday morning. Okay.
Oh, he probably only has to do it.
Already sent the email out. We'll see how good it is.
Yeah, what we need to get. Yeah. Can we, let's bring out the defendant.
Harold. Yes. Well.
No.
I'm gonna go.
Looking ahead to we got a really brutal civil week coming up. There was one you had scheduled for sex offender registry on Monday. I'm looking at it. I doubt the state was actually served because the people on the entry of appearance are gone from the DA's office. So it may be worth forwarding the notice of the hearing. Forward it to Cheryl. Tell Cheryl to forward it to, I think it's Potter. Oh, no, it'd be actually to Pennington. Tell her to just forward it to Pennington because he's. All right. Deputy Scott. State may proceed with rebuttal closing argument.
Thank you, Your Honor. May I please support, ladies and gentlemen? Like I told you in the first part, when we started, well, first of all, the first thing I want to say is thank you for paying attention. Thank you for being here. Thank you for all that stuff. And I won't take any more of your time because I just want to take a bit more of your time. I know it's been a long week. And it's not over because it's time for y'all to determine. Speak the truth. The truth is, there's absolutely not a shadow of a doubt in this case. They want to believe that the only reason he's here is because there's something has nothing to do with this case. Don't let it get into this case. Don't let sympathy, don't let anything go in your mind in this case. Stick with the facts. Like I told you when we first started, all roads lead there. They lead there. There's no question. I mean, you can have some things. This case has everything except for a live witness. That defendant took care of it that night when he shoved a knife into Kate Thomason's head and tied her after tying her to a chair, making her fight and struggle for her life. Yes, and beating her. That's what he did. There is no question that's what he did. DNA? Yeah. It tells the story of this case. I mean, I think there was some mention about how with two people excluded. That's patently false. Remember, I mean, you have to remember the testimony because you're the ones that are determining. Christina Servito said that with two people, it was inconclusive, not an exclusion. Huge difference because they don't go any further on exclusions. When there's an exclusion, that's it. Kate Thomason did not deserve this. She did not deserve, she deserved to see her grandchildren the next day. Not to be tied up in her own chair, murdered by that defendant. With her blood, her life dripping away from her. And to suggest that there's no evidence is patently ridiculous. There is so much evidence here, ladies and gentlemen. There is the DNA evidence. I think there's been some suggestion there may have been a vacant house. And I don't know what the suggestion is. The DNA doesn't travel house to house. There is no way the defendant's DNA gets inside of that house on the last piece of clothing that Kay had on before she died. And to suggest that there's anything of a frame, a cover-up, a desperation, J.T. Williams went the extra mile. Everybody understands that. I hope everybody does. He went the extra mile. Nothing was good enough except for him to solve this case. And a lot of times, what he had to do in those 6 agonizing months, because as you could see from the stand, this was a case he needed to solve. He needed justice for Kay. He had to have it. Now, he went carefully about it. He opened all doors, looked through everything, used every tool that he had. And all roads lead back to that defendant. And that defendant alone, nobody else. There's some suggestion. Remember the DNA. The DNA excludes. Now, let's just say Timothy Bryant. Yeah, his DNA was in the house. That makes sense. That absolutely makes sense. He was cleaning the house the day before. His DNA should be in that house. But this defendant's DNA should not be in this house unless he's your killer. And that's what happens. That's what happened. And then you have to Google. The Google takes him, and you saw, and I'm not going to put all these slides up because you've seen them. You know what they, and if you know, you can look at them again. I'm not going to take up any more of your time. But they all draw the lines in the circles. It's like a jigsaw puzzle, ladies and gentlemen. They're all pieces. These are all pieces. Is one enough? I don't know. I think so. It doesn't matter. So you have, and you know, everybody knows what jigsaw puzzle. You know, at first when you spread it out, throw it out the desk or table, doesn't make any sense. And then you look at the picture. Then you start looking at the way the pieces are clipping together. And as they click together, that sailboat starts to come into view. So, ladies and gentlemen, there is simply no other conclusion. Now, I don't argue with defense attorney that the state needs to prove the case beyond a reasonable doubt. But there's one thing we don't have to prove: unreasonable doubt. The only way this defendant would be not guilty is unreasonable doubt, because there's no other explanation for all the things that line up. It's like that colitis, or I don't know, like polarized sunglasses, I guess, is maybe a good way to describe it. Now, polarized sunglasses, when you tilt your head, it gets a little foggy. But then when you get it at the right angle, everything lines up and it's crystal clear. That's what we've given you this week. A crystal clear case. There is no doubt that James Jones murdered Kate Thomas. Want to know another thing about the Google? What else did the Google tell you? Not only did it have it wrap around her house, have it go up to the MARTA station. Did you see pictures of? You saw pictures of the defendant getting on that MARTA train. The times match up. All the polarized filters, they're matching up. They're all matching up. And then you've got location. searches. And I'll submit to you, ladies and gentlemen, this was no random event. You know it because of the Google. He searched her address almost a week before Kay was murdered. You saw the videos, or you saw I should say the camera, the house camera. This defendant stood, waited, let Kay come out with a broom, pick up a cat while he waited. More like a big cat waiting to spring. And he did. And we know he did because up in the top, he waited for her. That is the most horrifying thing that could ever happen. He let her put down the broom. And he used that bat that was in his hand. Cracked her on the arm. Because I know they made something about medical examiners and autopsies. Detective Williams was at the autopsy. He told you what her injuries were. He told you how her arm had a severe injury on it. He told you all those things. There is no doubt, ladies and gentlemen. There simply is, no doubt. Don't make it unreasonable. Don't go back there and manufacture doubt. Because there is none. Google. DNA. Car. Marta. All the polarized glass lines up. And it's crystal clear. This defendant, over the course of hours, brutalized and murdered Thomas, excuse me, a grandmother who didn't want to cause any fuss, knew things were weird, grew up old school, leave your doors open, that kind of thing. He just waited for her, stalked her, walked around the house with a baseball bat. We're waiting to pounce. No question, ladies. Defendant is truly guilty of all this. There is no doubt. I'm not going to take any more of your time. Thank you.
All right, members of the jury, that concludes the closing arguments in this case. It's now my duty to charge you on the law that applies. I do want to do that now because, as you might have guessed, this process only takes about 10 to 15 minutes, but as you might have guessed, 2 of you are alternates. And so if I can charge you now, then 2 of you won't be coming back tomorrow. So you'll receive a copy of these charges during your deliberations, and as well as a copy of the indictment and the other evidence that we're allowed to have in the jury room. So with that, you are considering the case of the state of Georgia versus James Jones. The grand jury has indicted the defendant with the offenses of murder, felony murder, 3 counts, aggravated assault, false imprisonment, burglary in the 1st degree, and theft by taking. However, the count of theft by taking has been removed from your consideration. This count and its removal should have no impact on your deliberations. You'll be provided with a copy of the indictment and these instructions during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in the defendant's favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. Vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch, and may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof by facts or circumstances, by direct evidence, from which you may infer other related or connected facts that are reasonable and justified in the light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors, and among those factors are the credibility or believability and accuracy of the witnesses who were involved in the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that 1, the acts of a person of sound mind and discretion are the product of that person's will, and 2, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. For malice murder, the state must prove that the defendant 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If the killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in an instant, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault, false imprisonment, and burglary in the first degree are felonies, which I will define for you shortly. Defendant guilty of felony murder if you believe that the defendant caused the death of another person by committing the felony of aggravated assault, false imprisonment, or burglary in the first degree, regardless of whether the defendant intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in a reasonable apprehension or fear of immediately receiving a violent injury. In deciding whether a sharp object is an offensive weapon, you may consider all of the following factors. the nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of the case. For false imprisonment, the state must prove that the defendant, 1, detained another person, 2, without legal authority, and 3, in violation of the person's liberty. For burglary in the first degree, the state must prove that the defendant, 1, entered and remained in the dwelling of someone else, 2, without authority, and 3, with the intent to commit theft. A dwelling includes a house or any building or structure that is intended to be used as a residence. A dwelling also includes any part of that house, building, or structure. It doesn't matter if the building was occupied, unoccupied, or vacant when the alleged burglary happened, but you may consider these factors in deciding if the dwelling was meant to be used as a residence. The state does not have to show that an actual theft happened to prove a burglary. However, you must determine that the defendant intended to steal. An intent to steal may be shown in many ways, arising from the facts and circumstances proved during the trial. Where there seems to be no other reason for entry, you may conclude the defendant intended to steal if the defendant made entry without authority and items of some value were found inside. It is up to you to decide whether the defendant had the intent to steal. The law provides that criminal action shall be tried and indicted in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, that the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did on or about June 27, 2018, commit the offenses as alleged in the indictment, you'd be authorized to find the defendant guilty. If you do not believe that the defendant is guilty of an offense, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant. By no ruling or comment that I have made during the progress of the trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence, according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status, for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict, to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial, or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous. That is agreed to by all, and that verdict must be in writing, signed by one of your members as foreperson, dated, and returned to be published in open court. We have compiled a verdict form for your use during your deliberations. This will be provided you along with all the other materials in this case. Again, it contains blanks for you to make a decision as to each count that remains for your consideration, as well as a space for the signature of the foreperson. At this time, are there any objections to the charges given on behalf of the state?
No, Your Honor.
Any on behalf of the defense?
Previously raised, Your
All right, those are preserved. And so, jurors, if I could get a show of hands of our jurors 32 and 27. All right, y'all are our alternates, but you're not released immediately from the obligations of your service. There are certain circumstances where we may need to sub you in. So what I will do at this time is I'll excuse you. You may know the obligations of your oath. Feel free to go about your business tomorrow. And if you could be on an hour call if we need you to come back to the courtroom. Is that going to be possible for both of you? All right, seeing a nod of the head. And then we're going to reach you by telephone to let you know when you are finally excused from your duty or if we need you to come back to the courthouse. Any concerns? If not, y'all can feel free to step out. And if we don't see each other again, I want to thank you very much for your service. All right. All right, as for the remainder of our 12 jurors, the attorneys still have to compile the exhibits that they're allowed to give to you in the jury room. That takes some time. So what I'm going to say is tomorrow there's no need to be here until 10 o'clock. And at that point, at 10 o'clock, we'll send back the exhibits, the indictment, the instructions, everything else you're permitted to have. And from there, we're on your time and we'll await direction from you. We are going, unless something goes horribly wrong, we're also going to be trying to provide some lunch for you, bring some pizza at around 11:30. Feel free to pack your own if you want, but we should have food and drink available for you around that time. And so with that, again, I'll ask you, even if some of you come early tomorrow, don't begin any kind of deliberations until all of you are present and you've received all the materials you're supposed to have in this case. So with that, again, thank you for your patience today and you are excused. We'll see you back here at 10 o'clock tomorrow morning.
Lost my dirt.
All right, counsel. I believe all that remains is trying to figure out what exhibits go back and which ones don't. Do we think we can do that process in 30 or 40 minutes, or what time would you propose showing up tomorrow?
I definitely want to get here early enough to take care of it. I want to give myself at least an hour to go through it because I know this has been an interesting exhibit. Yeah. Yeah.
So then I would propose 9 o'clock.
Exactly.
Yes, sir.
And y'all can start working through those issues. And then once you have, things that you think I need to weigh in on, we'll put those on the record. I'll also put out that because there are a lot of silent videos in this case, we do have a scrubbed laptop that doesn't connect to Wi-Fi. And so if instead of having them come out to rewatch silent videos, I think there would be authority to send a laptop back for them just to be able to watch surveillance footage that doesn't have sound. That wouldn't be violated by the continuing witness rule, but we've done before. And sometimes it allows them, prevents them from needing to come back in here if they wanted to watch that video otherwise. Something to consider. As I think it would only be video recordings with sound that implicate continuing witness. Other than that and coming back at 9 o'clock, is there anything on behalf of the state to take up? All right, anything on behalf of the defense?
Judge, I need to look into the aspect of the video going back. So that they can play it in the back. I didn't think that was allowed.
So certainly we'll work through all those issues before we send anything back at 10 o'clock tomorrow. I think the ideal would be, again, by about 9:45, let's plan to at least go back on the record, if not earlier, with a stack of what you propose going back, organized with our verdict form, our charge, everything else we need. And we'll also address that as well. Anything else on behalf of the defense?
No.
All right. See you tomorrow morning then. We'll be in recess. Or maybe not.
You open the court, it's nothing. I mean, what time you open your courtroom?
Deputy Scott, we should be, I don't think we have any 8:30. There you have it. Okay.
Because I tend to get in early.
All right. We'll be in recess till 9 o'clock.
I know I had to show off.
Off the record. All right, Ms. Smith. They just put that on top of their exhibits or with the indictment. Do you have the joint indictment by chance? Just put it with that. And then courts 2, I think it was the instructions.
Yeah, trial day too.
Oh, she in trial?
Yeah.
Where at?
Well, I can tell you.
Yeah, 2, not 1. Just court's exhibit 2 and that verdict form and the indictment. Just kind of set that aside, or that'd be on top of all the exhibits.
It's a lot different than this. I imagine it is.
You know what? Those are fun.
It's a fight.
You just.
Well, I just want to keep them.
We're gonna take care of it.
Okay.
Yeah.